Cyrus said nothing. The co-owner of the store, Alice Chow, asked if he needed help and eventually accused him of stealing water, told him to empty his pockets. The adult son, Andy, who was watching, said the same thing. You took some water, give us back the water. Cyrus said, I took nothing. I didn't take anything. I didn't take anything. And they continued to verbally attack him, accusing him of stealing water. Interestingly enough, if you look at that intricate camera system, Cyrus is telling the truth. He took nothing from that store that day. As he tried to walk out of the store, they continued to verbally harass him to the point where he took his backpack and calmly walked out of the store. Again, we know that to be true because of that intricate camera system that Rick Chow installed. And as he walks toward that door, the co-owner, Alice Chow, says something in Cantonese that makes her son run around the counter towards Cyrus. And then Rick Chow, the defendant in this case, comes from out of an office in the convenience store, armed with a .45 caliber Glock pistol, and follows Cyrus out of that store. Cyrus walks out of the store, takes a right, slowly, and hears them yelling, running after him, turns to see, and again, the camera system shows these things, and he takes off running. Cyrus tries to run through the parking lot to the point to where he runs out of his Air Force One Nike shoe, runs out of his shoe, doesn't turn around to pick it up because you have an adult male running behind you with a .45 caliber Glock pistol who has falsely accused you of stealing. So he runs. He drops 2 cell phones out of his pocket. We know this to be true because there are witnesses who we expect you'll hear from who'll talk about how they had to throw on brakes to keep from hitting them as they ran across traffic. We know this to be true because of that intricate camera system that he installed. He drops 2 cell phones. One belonged to him, one to his mother. Doesn't turn around to pick up one of those cell phones. Continues to run, falls down, gets back up running, falls again, busts his shin, drops the backpack, keeps running. In total, Rick Chow and his son chased Cyrus Carmack-Belton over 130 yards off of their property onto a public road in Columbia, South Carolina. And eventually, after Cyrus fell a couple of times, Rick Chow fired the fatal shot, which ended his life. Folks, 130 yards is a football field. No, in fact, it's a football field goalpost to goalpost plus 10 yards. Ladies and gentlemen of the jury, I'm Byron Gibson, the 5th Judicial Circuit Solicitor, and I, along with Dale Scott, Stephanie Taylor, and Weston Leifer, represent the state of South Carolina. So for the next few minutes, I'm going to give you a little bit more of a roadmap of what this case entails, what our position is in this case, and what we believe we can prove, as well as give you an idea of what to expect from the court and how this proceeding will run for the next several days. Now, I mentioned to you a moment ago that when Cyrus walked into that store, he was wearing a red hoodie and a pocket in the front, black backpack. Unbeknownst to the Chow family, to Rick Chow, to Alice Chow, or to Andy Chow, he had a pistol in the front pocket of that hoodie. Unbeknownst. They didn't know. We know that to be true because that video will confirm all of those things. Confirm that he walked around the store, had a conversation with them. At no point did he ever threaten them. At no point did he ever curse them when he was being falsely accused. He didn't spit on them. He never attacked them. He calmly walked through the store and calmly denied stealing anything from that store, which again was true. The truth in this case is that Cyrus did what you'd expect an adult to do in that case. He walked away. He tried to create distance every time he was confronted. But for some reason, Rick Chow wouldn't believe him. He couldn't believe him for some reason, although the evidence will show that he took nothing from that store. The evidence will show that after they chased him out of his chute, dropping phones down Springtree Road, after he tripped over a curb, fell, dropped his backpack, we believe that gun spilled out of that pocket. And within moments after that gun spilled out of that pocket, that man shot Cyrus Carmack-Belton in the back with a .45 caliber pistol. Now, we believe evidence will show that soon after EMS and others came on the scene, Rick Chow tried to say, hey, I was defending my son. But the interesting thing about this process is that you're going to have an opportunity at the end of this case, that you've heard all of the evidence from this witness chair, to assess what you've learned and what you've heard. You get a chance to assess that. And I'll ask, as you start asking those questions that bounce around in your head, in what world do you get to falsely accuse a 14-year-old of stealing, chase a 14-year-old 130 plus yards down a road while you're armed with a pistol, shoot that person in the back, then claim you're defending your son? Folks, it's for that senseless act, for that ridiculous act, for that heinous act, that Rick Chow, the defendant in this case, has been charged and indicted with the crime of murder. And it's for that crime that we, the prosecution, Dale Scott, Stephanie Taylor, and Weston Leifer, will be asking that you return a verdict of guilty at the appropriate time. Now, as prosecutors, we have something that's called the burden of proof. And what that means is we have to prove beyond a reasonable doubt that Rick Chow murdered Cyrus Carmack-Belton. Now, reasonable doubt in South Carolina, our courts have defined it a couple ways, and I'll explain those to you. Reasonable doubt is the amount of doubt that causes a reasonable person to hesitate to act. The amount of doubt that causes a reasonable person to hesitate to act. There's an alternative definition that says that if you are firmly convinced of a defendant's guilty, and at that point they are guilty of a crime. But that's for you all as the jurors to decide. Now, as was mentioned a few moments ago, Judge Taylor is the judge of the law, and you've got to take the law as he gives it to you. So at the appropriate time, he'll advise you of the definition of reasonable doubt and every other legal standard and every other thing about the law that you're going to need to know. He'll advise you of those things at the end of the case at the appropriate time. But the cool thing about this process, just as he said, is that as Judge Taylor is the judge of the law, you guys are the judges of the facts. And you get to determine based on what you hear from this witness chair and the evidence that you observe, you get to determine what actually happened in this case. So you're probably asking, all right, well, how am I supposed to do something like that? How am I judging people about, as a witness? I suggest to you that just as you are judging my credibility and believability right now, that's a skill that you've developed over all these years that you've been walking this earth. I suggest to you that when you parked your cars this morning, you didn't leave your common sense in the parking lot. That's what you're using to assess credibility and believability. And that's what you'll be doing with each of the witnesses that comes up here. You'll judge that. You'll talk. You'll have an opportunity to determine if they had motive to say what they say, if they could observe the actual things that they're saying they observed. If they have some reason to change or to try to tell a story in a way that's going to help them. You'll get a chance to make those determinations at the appropriate time. And we'll ask that you do that. A couple moments ago, each of you guys took an oath to well and truly try the facts of this case. And what that essentially means is that you got to try the facts of this case, not some stuff that you may have heard out there, not some preconceived notions, not some ideas that you may have, but from the evidence that you hear in this jury room this week in this case. That's what you got to do. Folks, I ask that you resist the urge to turn this trial into some type of commentary about youth and guns, because it's not about that. It's about a grown man who falsely accused a 14-year-old of stealing, chased him down the road while armed with a pistol, shot him in the back, and then claimed he's defending his son. That's what this case is about. And ultimately, those are the decisions that you'll have to make at the end of this case. Now, I expect that you're going to hear from several different types of witnesses this week. Some are going to be what we call lay witnesses, just people who just happened to be driving up and down Springtree Road that day. Folks who saw what happened, folks who watched the Chows chase Cyrus across the street and shoot and kill him. We expect they'll have different vantage points, seeing things in different ways, but you'll have an opportunity to listen to them and assess what they saw. You'll hear from law enforcement, first responders, people who saw what happened and talked to witnesses out there on the street immediately after it happened. Some body cam, meaning the body cameras that they're wearing when they're talking. You'll see some of those things. Take that information. You'll also have an opportunity to hear from a few experts. And judge will explain to you what experts are and what expert testimony is and how you weigh expert testimony. Again, take the law as he gives it to you. And take the law from experts and determine if they have the ability to testify about the things that they say that they know, and how they came upon this information, and if this information was paid for. Ask yourselves those questions at the appropriate time. Now, folks, you're going to hear about 3 types of evidence. So I'm wrapping this thing up. I want y'all to get sick of me this early in the week. There are going to be 3 types of evidence you're going to hear about. One is direct evidence. Second is circumstantial. Third is stipulations. Direct evidence is evidence that you can see, that you can touch, that you can feel, and sometimes even smell. Circumstantial evidence is evidence that you can infer exists based on a series of facts. All right? Evidence that you can infer exists based on a series of facts. So example, we're sitting in here, South Carolina, it's probably going to be 80, 90 degrees with 100% humidity. If you walk out here at lunchtime and you see snow outside, it's 12 degrees outside. You see icicles hanging off of the different the posts and all that kind of stuff. You see a snowplow going through here. You see penguin tracks and maybe a polar bear walk by. You are in this room with no windows all day, but you can infer that it snowed because you see all of the evidence of snow. That's circumstantial evidence. It's just as good as direct evidence if you, the jury, determine that you believe that that's what took place. So direct evidence, circumstantial evidence, and last we're talking about stipulations. Stipulations are agreements between our table, the state, and that table, the defense team. They're stipulations, that means we have an agreement that a particular fact exists. And if we have that agreement and we alert judge that that agreement exists, then judge will have the opportunity to explain to you that that's not a fact that you guys have to haggle about or even argue about, because we agree that it's the truth. So direct, circumstantial, stipulations. Those are the 3 types of evidence we'll be talking about. And at the appropriate time, you'll have a chance to look at the facts of the case, and with the evidence, you compare that to the evidence and return a verdict that speaks the truth in this case. Now, my final ask of you is this. There's an 11th century philosopher named Omar Khayyam. And one thing that he wrote back then was, the moving finger writes, and having writ moves on. Nor all your piety nor wit shall lure it back to cancel half alive, nor all your tears wash out a word of it. Now, I know y'all are looking at me kind of like, what is this dude quoting some 11th century philosophy for? I'll tell you that at the end of this case, I will explain to you why something written back in the 11 and 1200s rings so true today in this courtroom in 2026 about a case where that man murdered a 14-year-old in 2023. So folks, remember what we've talked about and ask yourselves one last question. What is the value of a human life?
Please record. Yes, Mr. Swirling. Solicitors? Yes, sir. Ladies and gentlemen of the jury, good morning. My name is Jack Swirling. We met briefly yesterday when we were doing the jury selection. And it's my position at this point to go ahead and give you a defense opening statement. And I appreciate you being here. Thank you for being here. And I hope that you find this experience on your part to be an interesting experience about looking into your judicial system. We spent, let me just back up a minute. My good friend, the solicitor, just gave an outstanding opening statement himself. But the one thing that I did not hear, and the one thing that I do not believe you will hear during the course of this trial, is why a 14-year-old would be illegally possessing a semi-automatic pistol, wandering the streets with that pistol, with a laser attached to that pistol. A laser to go ahead and ensure better accuracy when you fire the weapon. A semi-automatic pistol that was loaded, the magazine was loaded, and there was a bullet in the chamber. It was illegally possessed by this young man. He illegally entered the store because there was a sign posted, it's illegal to go ahead and enter the store with a weapon. Versus what Mr. Chow did. Mr. Chow had a concealed weapons permit. He never drew his weapon. He was authorized to have a weapon, but he didn't draw that weapon until his son was in danger of being shot. The solicitors, in this case, want to frame this case. It was all about a bottle of water. It was all about someone wrongly accused of shoplifting in the store. But nothing else matters to the state in this situation as to why this young man had that weapon, why he carried that weapon. Because if he didn't have that weapon, he never would have had a weapon to draw on Andy Chow. He never would have had a weapon to put Andy Chow in danger. And he never would have had a weapon that would cause Mr. Chow to believe his son was going to be shot and have to make a split-second decision as to whether or not to go ahead and fire that gun and protect his son. There's going to be a lot of questions in this case, a lot of things that you're going to have to resolve. But I wanted to go ahead and tell you why this case is framed the way the state is doing it, because they don't want to explain why that young man had a semi-automatic pistol, loaded, bullet in the chamber with a laser, entering the store, wandering the streets. They don't want to explain it because you know what? They cannot. We went through a jury selection process yesterday that's carefully designed to go ahead and make sure that 12 people who will eventually decide this case, 12 people from Richland County, who are fair and impartial, who do not have any preconceived opinions, who've come in here under oath and said, I may have heard about the case, but I have not formed an opinion about it. I'm willing to listen to the evidence and the law that the judge gives me and decide this case fairly and truly and honestly. We went through a jury selection process where, as you recall, the judge excused a number of witnesses for one reason or another to make sure we had a fair and impartial jury. The state excused witnesses because the lawyers, both sides, are entitled to go ahead and make challenges to witnesses or peremptory challenges. We have challenges that we can exercise because any reason whatsoever. However, what it comes down to is that both the judge, the state, and the defense believe that we have the 12, 13, 14, 15 jurors now who are the most fair and impartial jurors who can sit in judgment on this case and decide whether or not Rick Chow is guilty of murder, whether or not he intended to kill this young man and he did it with malice, an evil heart, a wicked mind. That's what malice, judge will describe to you what malice means. And you will have to decide whether or not the state has proven that case beyond a reasonable doubt. So we are satisfied, we are content that we have the best jurors that could come out of Richland County to decide this case, and we have faith in you. Rick Chow has pled not guilty to this offense, and that places on the state the burden to prove guilt beyond a reasonable doubt. I just want to cover a couple of legal issues, legal principles with you. One is, as he sits over there right now, and throughout the course of this trial, all the way through, he is presumed to be innocent. That's not just a legal fiction. That's not just something you hear on TV and Law and Order or some other one of the great police shows or law enforcement shows on TV. The presumption of innocence is the bedrock of our judicial system. Everybody accused of a crime is presumed innocent unless and until the state proves guilt beyond a reasonable doubt. That presumption of innocence is so strong on our law that you are to consider and presume Mr. Chow innocent unless and until, at the end of the case, after you've heard all the evidence, after you've heard the judge's instructions on the law, you go in the jury room and 12 of you agree, 12 unanimously agree that the state has proven guilt beyond a reasonable doubt. That presumption of innocence does not disappear during the course of this trial. Now you may say, well, that's kind of difficult.
Hey, Gwen.
It is our law. It is what makes us different than everybody else on the face of the earth. The state has to prove guilt beyond a reasonable doubt. And until you go in the jury room and decide that the state has met its burden of proof, he's presumed to be innocent. Now, proof beyond a reasonable doubt doesn't just mean any doubt, but you have to prove the case beyond a reasonable doubt. In other words, I believe, or I think, maybe, any one of these words, that is not enough.
It's
to
okay.
Go ahead and convict someone.
I missed my
It has to be
pockets.
beyond a reasonable doubt.
This room is way too big.
It's not enough to say,
The ceilings are way too
I
tall.
think the state met its burden.
I
of proof.
tried to
think
do
state
the
proved guilt.
caucus situation again, but
That's not-
realized there were no
it's beyond
outlets
a
in there
reasonable doubt. And
at all.
the reasonable doubt
So that was not going to work.
can come from the evidence or the lack of evidence. Either way, you are the ones who determine whether or not the state has met its burden of proof, proving the case beyond a reasonable doubt.
But in this room, I can literally
You're
put
the
up
ones that apply
all of my
presumption of
stuff.
innocence. Not the judge, not the lawyers, not the parties, but you. The state also has a burden
Yeah, I hope so.
of disproving
I've been sad
self-defense.
since I've been here.
And this is a case of, it's a side or it's a collateral issue to self-defense, whether or not someone has a right to exercise self-defense and take another human life. Self-defense is probably the
There are
oldest
lots of
principle we have as man.
The ceilings are
All
like,
the way back. You have a right to defend yourself.
I don't even know.
You do not have to wait
And
until
there's
someone
windows
goes
way
ahead
up
and
high.
shoots you, kills you, or stabs you, or no matter what it may be. It is elementary, it's fundamental that a person has a right to exercise self-defense, the law of self-defense to defend himself or herself.
There's rabbits
And it
everywhere.
also applies to defense of others. Same principle.
I know.
You are entitled to go ahead and defend
trying
other people
to adjust.
in a similar situation. For example, your son, which is exactly what we have here.
I don't know anything about this trial.
Because if the state doesn't prove beyond a reasonable doubt that Rick Chow did not
But from what I
act
can
in
tell
self-defense
in the
or
long
defense
time
of
chat,
others, then they
they
failed.
want this man to
They have
hang.
failed to prove the case. There's no burden on any defendant to prove anything in the case. So the state has to prove guilt beyond a reasonable doubt.
Oh,
And they have
Neo
to
is having a
disprove
blast with the rabbits. He
self-defense
is after them.
or defense of others beyond a reasonable doubt.
He is chasing rabbits.
We know that you're going to hold them to that burden of proof and keep our system the way it was designed to be. That a jury
We also have
sits
bobcats,
between
though,
the
so
state,
it's pretty crazy.
federal government,
It's crazy out here. I
citizens
also
of
have
the
wasp
county
nests
in
like
the
out
area,
of just everywhere.
and
So I'm
decides
trying to
cases
get all
fairly
wasp nests
impartially, and that no person
down.
is ever held to answer for a crime where the state has not met its burden of proof. The judge will describe to you what the definition of murder is. And I told you it's malice.
I have a
aforethought.
lot of trees.
That's what South Carolina standard is.
Lots and
Murder
lots
is
of
with
trees.
malice aforethought. You kill somebody with malice aforethought.
I actually have scenery to look at, not just stuff in a
Wicked mind.
caucus.
The offense of murder also requires, as the judge will tell you, a criminal intent.
Harley Gregg is going,
You have to
to
have a
appeal
criminal
today.
intent to go ahead.
That's
and
at
commit
10:30.
the crime. You have to intend.
kind of excited
the
about that.
crime. And the judge will explain that to you at the end of the case as well. And I'm not going to go into the details of it, but I just want to turn these principles over to you so you know what we're talking about. Self-defense, defense of others. Was there a reasonable belief or an imminent danger? Was the imminent danger, and you believed it was reasonable, and it was reasonable, that someone's life was in danger, your own life or the life of a loved one, like Andy Chow? Under those circumstances,
I've got to see the convenience store footage of this.
you are
because
entitled to go ahead and exercise that.
This is wow.
Self-defense or defense of others.
This is
The
yet
judge will
another
explain to
case
you,
that we
as I
watched
just said, that
that
it
is,
is up to the state to disprove that. You will hear evidence of that. You will hear in detail exactly what happened out there on that street.
I mean, oh,
And
he's
what happened
going for
when
also
Rick
a new
Chow
trial.
Went ahead and fired the shot.
Yes. I mean, he could be. I
Young
always
man
thought,
was
I've always
pointing a
wondered
gun
if he could be.
at his son. Defense
I
of
don't
others.
know.
Is that an immediate threat, an imminent threat? Is it a reasonable belief that your son is in danger of serious bodily harm or death? I submit to you, there's not going to be any question about whether or not it was reasonable or whether it was imminent, or it was reasonable to believe it was imminent. And you are, under the law, since the beginning of time, allowed to go ahead and take, unfortunately, nobody's saying this is, everybody's happy about this, but unfortunately, there are occasions in human life when someone has to exercise that right of self-defense or defense of others, and another life is taken. It's sad, it's tragic, there's no question about that. My heart goes out to the family. They've suffered a tremendous loss. And I don't want you to think
I
that
know.
we're making that.
Isn't
right
that
about
crazy?
that.
There's been a lot of weird
This is
stuff
a
going on.
terrible
Chemical
situation that
leaks,
happened. That young man
explosions.
is no longer with us.
It's just been
But there
craziness.
are legal issues before you that you must decide prior to making any determination.
And all
about
these
it.
weird evacuations. I mean,
I submit to you right now that the state will not and cannot meet its burden of proof, proving guilt beyond a reasonable doubt, proving murder, malice aforethought beyond a reasonable doubt, criminal intent beyond a reasonable doubt. or disprove the defense of others, as the judge will explain it to you. Now, how do you decide that? Well, you're going to listen to the evidence. You're going to hear the law by the judge.
Oh
and
my gosh.
You're going to
We
make
were
your decision
moving,
based upon
obviously,
that evidence that you
and
hear and
we
the
had
law
to
that
make
the judge gives you at the
individual
end of the day.
trips because it was
No,
so
there's no
expensive to
schooling,
get a
there's
U-Haul
no,
truck.
we don't have any
So we
classes to how to go ahead
Drove
and
an
determine
hour. It
that.
takes over an hour to
But I
drive
will tell you this,
from one house to the
reasonable
other.
doubt is
We
something you
made
use
individual
and
trips.
exercise every single
And
day
one of
when
our
you make
trips,
important decisions in your life.
One of Mike's
Should I go
coworkers
to that
called,
school? Should I buy that
and,
car? Should I buy that house? Do I
said
need this? Do I need that? You weigh
one of
the
his other
factors,
coworkers was
both the
killed on
pros
his
and the
motorcycle.
cons. And
Not
no
for-
matter what the pros and cons are, you're still entitled
It's like,
to go
what the
ahead
heck?
and make that purchase or go to that school or go on that trip, even if it all adds up to being not the right thing to do. But when you come into a courtroom, it's completely different. Because if you have a reasonable doubt, if things just don't make sense, if it doesn't add up, it doesn't, one thing after another make sense, and come to a conclusive
Let's figure out what
decision
is this
that the
case.
state has proven guilty beyond a reasonable doubt,
So
you can't disregard that. The oath that you just took requires you to find someone not guilty or not proven, is another way to look at it, not proven beyond a reasonable doubt.
oh my gosh. Oh my
Submit
goodness.
to you
We
at
have
the end of this
destroyed this
case,
guy's
again,
business.
Hearing the law and the evidence or the lack of evidence, you will come to that decision that the state has not met its burden of proof as to proving case or disproving self-defense or defense of others. You look at the evidence, you listen to the witnesses. Are they consistent? Have they told the same story, the same, everything that they've seen, everything that he did, is it consistent all the way through? Not only is it consistent between what they said, but consistent with what other people said. And not only consistent with what other people said, but is it consistent with the physical evidence that you know and that you see and is presented to you in the court? You look at motive and interest and bias and prejudice to decide whether or not to believe a witness or the credibility of witnesses. You are the folks that decide the credibility of witnesses. I want to go ahead and, as I've said, it's a tragic situation. My heart goes out to the family that they've lost, a terrible loss. Nobody can understand that. Nobody can in any way comprehend what it would be like to go ahead, and I feel sorry for these folks. And I feel sorry for the young man who lost his life. But it's also about the Chow family. Rick Chow and his wife Alice Chow. Rick was born in Hong Kong. Alice was born in Malaysia. They came here early on in life as students. They went to Louisiana, University of Louisiana. Rick Chow and Alice Chow became citizens of the United States, as proud American citizens as anybody could possibly be. They married. They had 2 children, Andy and Kenny, who've both gone to the University of South Carolina. Alice was a CPA, earned her CPA degree and a license. Rick Chow was a professor
Protest.
at Upper State Carolina for a number of years in computer science.
Oh, this is not a good situation.
These are motivated, energetic people who wanted to pursue the American dream, and they did.
This is not a good
At
situation.
some point,
This is
they
going to
wanted
be about
own a business, and that's how they came to buy the store that's in question today. They had that for about 10 or 12 years. They bought it. It's a Shell gas station. They bought the store and they operated it. Rick Chow really wanted to go ahead and form a business. So for 10, 12 years, they've operated that business.
okay. The question is also, what is a 14-year-old doing with a semi-automatic
May,
weapon?
as the solicitor has told you,
Nobody,
the situation that's before you.
I mean, I got questions.
Young man, Carmack-Belton, entered their store. Now, when he entered the store, he had a backpack. Backpacks have to be put on the water cooler. It applies to everybody. They don't want anybody walking around in the store with a backpack. So everybody puts it on the water. Mr. Belton Carmack did. Put it up. You will find out, we'll talk about what's in that book bag later on, but the young man entered the store, walked around, all around the store, not buying anything, looking at different merchandise, not buying anything, going to the water cooler, strangely removing 4 bottles one at a time, then strangely putting them back one at a time, looking nervous, his hands in his pockets, looking back at Andy Chow, looking back at Alice Chow, who was on the floor at that time. They were both in the store in a nervous way. And they had a suspicion that he possibly had shoplifted something. Now, this is a store with thousands of small dollar items. A water bottle or any other item in the store, probably very little profit in it. So it's not about whether or not one item was ever taken, it's the cumulative effect and the losses that a store owner can feel from that. So they have a right to go ahead and look and see if anybody's taking anything. When Mr. Belton was leaving the store, he was asked, "Did you take anything?" And he basically had his hands in his pockets and he turned it up, the pockets. "No." "Do I look like I have anything?" He was asked again, and at that point, he went to the water cooler, picked up the book bag, and at that point exited the store. There was no physical confrontation. There was no yelling at him, but there was a request. There was a question that he answered, but Andy Chow still felt that there was something about the way he was acting in the store, and he wanted to follow. He could report it to the police. But at that point, when they exited the store, Mr. Belton, Carmack-Belton, started running. Now, he saw something that he thought, Andy Chow saw something and he thought looked heavy in his hoodie, in the pockets of his hoodie. And that could have been something that he took, like the water. Well, we now know that it wasn't the water, but it was a semi-automatic loaded pistol with a laser on it in those pockets. So he was telling the truth that he saw something heavy in the pocket. The suspicion increased when the young man took off running. Why was he running? Why did he run? He did increase the suspicion at that point by running. And he really ran fast because he ran out of one of his shoes. He threw the phones down before he exited the parking lot. And he just took off as fast as he could. Now, reasonable to believe that he may have taken something? Absolutely. Reasonable to go ahead and follow him to see where he was going, in what direction, so he could tell the police? Absolutely. And he wasn't going to tackle him. He wasn't going to hold him. He wanted to see where he was going. Rick Chow had come out of the office and he saw his son outside and the young man outside as well. And he saw him both of them take off running. Rick Chow, the defendant in this case, ran following his son and Mr. Carmack-Belton because he was trying to see what was going on with his son, protect his son, make sure his son was okay. He did not know what was going on. He had nothing to do with the determination in the store. But he was going out there to protect his son, to make sure his son was okay. It's his son. The young man
Oh,
rolled down
nice.
the street, crossed over the street, ran down on the left side of the street toward the apartment complex. And at some point, he tripped, fell. Mr. Chow was behind him. Andy was somewhere, and you'll hear the testimony about it, somewhere in that area on the street. And actually, the young man hurt his leg, cut his leg. But when he got up, and by the way, he also threw his book bag into a ravine down there. Why? What, do these things increase suspicion? Absolutely. It would increase anybody's suspicion. But when he came up, and Andy Chow saw that he had a pistol in his hand. It turned out to be the 9mm pistol. That one in the chamber was loaded and had a laser that had been attached to it, but the laser was found in the road, right near the road where the shell casing that was fired out of Mr. Chow's weapon landed. Now, Mr. Chow never pulled out that weapon. The state wants to talk about, well, you know, he ran from somebody who had a .45 automatic. How would the young man know that? He didn't even see Mr. Chow. Mr. Chow had it in a holster the whole time. He did not pull out his weapon from the holster until
I apologize. Just a joke. All right, overruled. Go ahead, Ms. Work.
he didn't pull out his weapon until he was told by his son that the young man had a gun. The young man, Andy being a young man as well, when he saw the gun, started backing up like this, had his hands up, backing up into the street. Mr. Belton pointed the gun at Andy Chow.
Oh,
Mr. Chow told him, drop it. He didn't drop it. Andy yelled out, he's got a gun. He's standing in the road. Mr. Chow is coming up, pulls his gun now. At that moment, at that split second, that frozen moment in time, Rick Chow sees a young man pointing a semi-automatic pistol at his son, who's backing up with his hands up, and Rick Chow fires his gun to protect his son. We submit to you that that was reasonable. It was a reasonable impression that his son was possibly going to get seriously injured or die at the hands of somebody who had a gun pointed at him, that was a reasonable belief. And he fired his weapon under the law in defense of his son. As I submit to you, anybody in this courtroom, consistent with that, what I'm telling you right now, it's consistent with what has been said in this case by the witnesses. And you will hear testimony from various people that you will find is consistent with that version of what I just told you is consistent.
but he was
There's no
shot in the
question
back.
that gun belonged.
Unless he just
to this young
turned
man.
at just
There's
the
no
right,
question
just
that young man had that laser on that gun. As a matter of fact, you will see evidence. We submit that we'll be able to lay a foundation in our defense that he was on social media the night before, wearing the same clothes, holding the same gun with a laser. There's no question about it. You'll be satisfied at the end of
what
this
is the
case.
14-year-old doing
It's
with
about the
it?
direction
That's, I mean,
everybody was, where everybody was placed, in direction where Mr. Chow was when he fired the weapon. where the sun
Look,
was
man,
and where
I can't stand a liar, and I
all
even
of that.
worse
I
hate a
submit to you,
I
you're
hate a
being
thief.
consistent.
I can't stand a thief because
Mr.
I chase shoplifters for a
Chow did
living,
not take any joy in what
and it don't matter if it's
It was
$1
chaos.
or if it's
Adrenaline.
$1,000.
Can you
That
imagine what
costs
you're thinking about when you had
everybody
to go ahead and
money.
take that action to go ahead and first of all see your son with a gun being pointed
It
at
adds up.
by a 14-year-old, and then having
And
to
I don't
fire
care
the
if they're
weapon to
14
protect
or
your
they're
son.
40.
What was
I
going
will chase
through
the
his
damn
mind,
shoplifter.
what was going through his heart, what was going through his head,
I will get you.
wasn't something he did because he wanted to. He did it because he was trying to protect his son. But the state doesn't talk about.
And not only that, I bet they didn't know the person was
State
14.
doesn't
You don't know how old these
any
people are.
explanation or rationalization as to why that young man.
This is
pulled
the
that gun
defense.
and was
This is the
walking around
defense.
with that gun in the streets of Columbia, South Carolina.
Dude, I've
Mr.
been to,
Chow didn't just run away at that point. He rendered aid. He stayed right there at the scene. He started doing chest compressions. You'll hear that. The young man was regurgitating. Terrible things, terrible scene. Mr. Chow was bending down, cleaning his mouth out, and giving him mouth-to-mouth resuscitation. You'll hear that. This is.
I mean, I'm not armed when I chase
I submit to you
shoplifters,
now.
but I have been attacked.
This
I've
is
been
a
hit by a
man who
car.
was
I've been.
deeply upset about what happened, to the point that he was doing some things that I wonder how many people would have been doing exactly what
Shoplifters are armed.
Save this young man. And then other people came over. But Rick Chow stayed there, did chest compressions, took vomit out of his mouth with his own mouth so the young man could keep breathing. And then other people, more qualified people, were able to go ahead and try and help the young man. Unfortunately, he died. Unfortunately. Mr. Chow stayed around, stayed at the scene. He was there when the police came, told the police what happened, gave a brief description. It was not an interrogation. It was not an interview. It was not a complete, what I would call an interview by law enforcement. But there were snapshots taken of different people, Andy Chow, Rick Chow, some of the people who were at or around the area there. He stayed there that entire time, went back up to the store, and when the police came up to the store, he showed the police the videos that they had. He was cooperating 100%, doing everything he could to not only save the young man's life, but also to cooperate with the police. Everything he could. His wife was doing the same thing. His son was doing the same thing. These were not people who had any kind of joy in what had happened. They were upset. It's terrible. Not as bad as obviously the parents of this young man, not nearly to that level. But having shot somebody and having someone died, it's got to be something that's just so difficult to go through. When he agreed, they gave over all the videotapes to the law enforcement as well that were in the store. They all agreed to go down for further interviews at the sheriff's department over the course of the next few days to give a real interview as to what happened bit by bit, word by word. But within 15 hours, before any of the investigation really had focused with detailed interviews.
Dang, his opening statement is way longer than the prosecution.
Whatever ballistics, DNA, whatever the issues were, within 15 hours, when Mr. Chow was called down, he He was told to report to the sheriff's department. He could be placed under arrest for murder. That's how long it took, 15 hours. Ladies and gentlemen, I again say this to you. The state wants to frame this as a situation where a young man may have taken some small item from a convenience store, wrongly accused, chased, and he wasn't chased, he was followed, chased and shot down because he had taken something from that convenience store. I submit to you, it's not that simple. You can't frame it like the state wants to frame it. Andy Chow had a reasonable belief that something took place in the store. He followed the young man out. Rick Chow had a reasonable reason to go ahead and follow his son to see what was going on to protect his son. Andy, when he saw the pistol being pulled, as the solicitor pointed out, 130 yards down the road, he started backing off with his hands up.
Yeah, thieves have more
His
rights
father
than
saw that pistol being pointed at his son
people do.
with and by a 14-year-old young man. He had to make a split-second decision to go ahead and defend or not defend, fire or not fire, to protect his son, his pistol. What should he have done? Because that's what the state is trying to get doing Monday morning quarterbacking. That's what it's all about now. I submit to you, and I'm going to sit down in a moment, and I appreciate you listening. There are 3 questions in this case. One of them is no particular order. But what was the 14-year-old doing walking around Columbia with a semi-automatic 9mm weapon?
Columbia, South Carolina's such garbage. It's not one of my favorite places to be.
Illegally possessing that weapon, illegally walking into a store that barred people coming in with weapons. Another question is, would any reasonable person believe that their son was in imminent danger of death or serious bodily harm such that they had to exercise the right of self-defense? And what would any reasonable person, the third question, what would any reasonable person do under the same circumstances? Fire or not fire? That's something that everybody's going to have to think about. Mr. Chow told him to drop the gun. He didn't. Mr. Chow had the gun in his holster. He didn't pull it out until he saw it, or his son said he's got a weapon. Again, he made that split-second decision. There was no malice. It doesn't even fit the definition of what murder is in South Carolina. With malice, protecting your son. No criminal intent. Fired one shot, stayed there, tried to render aid, life-saving aid, and cooperated with law enforcement. Stayed on the scene. Agreed to further interviews. Then was arrested within 15 hours. Quick decision. I'm going to sit down now, and I do appreciate you listening to me. I submit to you there's one scenario more frightening than a man walking around the streets of Columbia with a pistol, semi-automatic pistol, one in the chamber, just walking around town with a laser. on his gun. There's one scenario, more dangerous than that, more frightening than that. Is a 14-year-old.
Yep.
Walking around town.
Yep.
With a semi-automatic pistol.
Ain't nothing good coming from that.
Chamber with a laser on his gun. How frightening is that? A 14-year-old does not have the education, the training, the experience of making good decisions, sound judgment decisions. That is more frightening than anybody in that same situation. And that's what
Hey.
I challenge the state at this time to offer some justification or rationalization as to why this young man illegally possessed a semi-automatic pistol with a laser and entered a store with that.
So everybody I know in the law and crime chat is like, it doesn't matter that he had a gun. It don't matter. He was 14.
You're entitled to
it
know
don't
why.
matter. It was water. It don't matter.
At the end of the case,
You don't shoot someone in the back. I know everybody in that chat is justifying why this 14-year-old had a gun. It's the most asinine thing.
And that they have not disproved beyond a reasonable doubt that Rick Chow acted to defend his son's life. And it was reasonable because it was an imminent danger to his son of death or serious bodily harm, or he reasonably believed that. Thank you.
Thank you, Mr. Lurlow. All right, ladies and gentlemen, we've been going just over an hour, and we told the first witness may be rather lengthy, so I'm going to take our morning break right now. Give everybody about 15 minutes to refresh themselves, stretch the legs, and also have to begin the process of sequestering the witnesses. I don't want you to infer anything from the fact that certain folks aren't in the courtroom, much like the selection process where I segregated you from one another to make sure your opinions influence your neighbors. Do that with the witnesses as well. So don't infer that anyone does not care about the case, has done anything wrong, or anything of that nature. They're just excused from the courtroom until after they testify. So if it is, we'll be in recess, let's say 11:20, and we'll be right back with you. Same as I told you yesterday, don't discuss the case amongst yourselves at all. Again, don't do any research, anything like that, and we'll see you back in here at 11:20.
Everyone remain seated to the jury, please.
Yeah, literally in the law and crime chat, they are saying it doesn't matter that he had a gun. He was 14.
Any exception to my instruction on sequestration?
None on behalf of Mr. Chow, Your Honor, pursuant to the court's ruling, we will have everyone who was on our witness list that we gave to the state, experts including, will be out of the courtroom until they're called.
And none of those witnesses.
Thank you. Very good. We'll be at these till 11:20.
Thank you.
I mean, it's really sad.
And again, we want to thank you all so much for joining us right here on WLTX Plus. I'm Chrissy Calcagno alongside former criminal defense attorney John Mobley. John, kind of give me your takeaways so far for this first half right before they go into recess right now. But both of the opening statements, what's your biggest takeaway?
Well, Krista, I got to call it like I see it. I know all of these lawyers, got a lot of respect for them. And, but, the first thing that I want to comment on is not even the opening statements, but an intangible, a visual.
So yeah, I think that's pretty shitty that people are saying that, hey, Mark, how are you? Thanks for joining. So today we're watching this trial about a convenience store clerk in South Carolina, Rick Chow, who shot a 14-year-old for now. Okay, let me set this up. This 14-year-old, now no one knew he was 14. This guy walked into his convenience store with a backpack and sat the backpack down on a cooler of water and took out bottles of water, and he looked suspicious, right? He was acting weird. And then they thought he stole bottles of water. Okay. And then they asked him before he left the store, hey, did you take something? And the guy was like, no. And then he took off running. So the guy from the store followed him out of the store. They called the police and were letting him know where he was going. And as this kid was running, he ran so fast that he ran out of his shoes, and he threw down his phones, and then he threw his backpack into a ravine. And then the next thing you know, this guy points a gun at the convenience store worker. And by this point, the convenience store worker's dad had run out to follow and see what the heck was going on. And the son says, hey, he's got a gun. And the dad also had a gun on him. He's like, oh, hell, he's got a gun. He's going to shoot my son. So before the kid could shoot his son, he shoots the kid. He doesn't know the kid is freaking 14 years old. And what the hell is a 14-year-old, hey, China, doing with a gun? Well, anyhow, apparently this kid turned at just the right moment because he got shot in the back. Whatever. I don't know. Why do we always end up with the cases that we're like, do we want the defendant to get freaking, I don't know, man. I chase shoplifters for a living. I don't give a shit if they stole $1 worth of shit or $1,000 worth of shit. You getting got. But I don't know if the kid stole the water for real or not. I don't know if he really stole anything. He acted like he stole some shit because he took off running and he threw things out and about, whatever. And then he had a gun. No one knew he was 14 till he was already dead. Dude's dead. He got shot in the back. He ran out of his shoes. He ran so fast. That's how guilty he was. But anyway, he had a gun. Well, he turned at just the right time. He didn't shoot him in the back on purpose. He was pointing the gun at his son, at the convenience store guy. So the father shot him so he wouldn't shoot his son. But the shop owner, it's wild. It's wild. So, but then when he realized he shot the kid, he rendered aid to him. He tried to help him. He tried to save him. And then he cooperated with the police. He did everything he could to save this kid's life, all the things. Why does a 14-year-old have a gun? Why does he have a gun? Why does the 14-year-old have a gun with a laser on it? Why does he have a gun? Because he pointed the gun at the kid. He pointed the gun at his son. And the son was like, oh shit, he's got a gun. So dad was like, oh hell no, you ain't shooting my son. So what you gonna do? What you gonna do? And you in and it's Columbia, South Carolina, okay, which we all know ain't the best place in the world. Exactly, right, China? They all have guns. Why do all these kids have guns? It's crazy. Okay. I get it, Mark. I see what you're saying. But China's like, it's not a shock anymore. It's not. I feel you. It's just crazy. I'm not understanding the whole but these people owned their convenience store. They've been shoplifted from all the time, and they were tired of it. They've been trying to catch people before they leave their store with their merchandise. Like, yo, give me back my stuff. I did this for a living, okay? I caught shoplifters for a living. I will get you. I don't care. But trust all the I wasn't armed, but all the shoplifters are armed. I mean, I'm telling you, I've been hit by cars. I've been punched. I've been kicked. I've been in fights. I've been in it all. But you gonna give me my shit back. And I cannot tell you. And you catch the same ones over and over and over again. They just keep coming back. Well, okay. I will tell you, because everything makes or breaks. At the end of the day, it makes or breaks. It's your business. It's your livelihood. It's everything. I chase so many people. So many. I chase so many people. I look back on it now. I don't know, girl. I don't know. I chase so many people. It is because if you don't get, it's also, it's I can't stand a freaking thief. I hate a liar, but I hate a thief like nobody. There ain't nothing like a freaking thief. I hate a thief. I will chase you to the ends of the earth for a pair of damn jeans. I will get you. I mean, I have been, it has been, girl, you don't even know. I had a dude come in one time for a job interview, and I watched him on the camera. I was like, this dude's going to steal. I didn't even know he was coming in for a job interview. But as soon as he walked in the store, I was like, he's going to steal. And he went back there for an interview, and I called to the back. I was like, yo, who is this dude? And they're like, oh, he's so-and-so's cousin. He's coming in here for a job interview. I said, he's going to steal. I'm watching him. And they were like, what? He's great. We're hiring him. I said, oh, no, you ain't. He ain't working here. And as soon as he was leaving the store, he stole a bottle of cologne. And then I chased him all the way up the hill, and I had the cops go after him. And guess what? He almost got shot. He almost got shot because his dumb ass reached in his pocket to take out the cologne. Girl, I will get you. The most shoplifters I caught at one time, not in one day, at one time was 11. Got all them wrangled up. Yeah, now they make videos. Now there's shows about it. I'm like, I could have made a show. I could have had my own damn reality TV show. I knew as soon as you pulled in the parking lot if you was going to steal. And don't talk to me about profiling. I don't even want to hear that shit. I knew you was going to steal. I knew by the car you drove. I knew by the way you parked. I knew everything. I knew. I had dead to rights. I was the best. I was number one. I loved it. I loved it so much. It was like hunting. It was so fun. It was so fun. You can't do that stuff now, but it was fun. And I had so many people. Okay, and I will tell you this too. I had this one Mexican lady. I tried to catch her for over a year. She would come in with her 2 kids and her husband, and she would steal something she was good. Gosh, she was so good. She would steal every single time she came in the store, but I could not catch her. Gosh, she was so good. And man, she was good. But I finally caught her. Finally. It took me a year to catch this bitch. Anyway, I finally caught her. But she would use her kids. She would use her kids, and she would use her husband, and she would always check out at a different register, and she would have her kids stealing stuff. Finally, I caught her. I got her deported. I was so happy. You have no idea. Because I was like, bitch, you don't come to this country and get all the free shit and then steal from me too. She would be like, oh, my friend. And she was like, please, my kids. I'm like, bitch, I don't care about you and your kids. You steal from me. You've been stealing from me for a year. Oh, I don't think you understand. You don't understand the satisfaction. I got so many people deported. You have no idea. I had one dude deported, and he came back. I caught him twice. Twice. I'm like, dude, what are you doing back here? How did you get back? I don't think you understand. Pissed me off. Pissed me off. I caught the same dude twice, got him deported, and he came back. Don't mess with me. Don't mess with me. Ooh, and one time I caught a guy. He came in. Yeah, he didn't steal anything. Yeah, he did. He actually didn't steal anything. But his actions after made them think that he did, because he took off running and he ran so fast he ran out of his shoes. This is not a good, this is a very sketchy case. This is very sketchy. It's wild. At the end of the day, it does not justify a person is dead. I'm really torn on this. Yes, we are moved in. This is my office. It is gigantic. The ceilings are so tall. I don't know how the sound sounds at all. There's no way I can fix the sound because the ceilings are so tall. This is but I can fit all of my Keanu stuff in this room. I tried to make a closet again, but realized that my closet had absolutely no outlets in it. So I am in the spare bedroom, and the ceilings are very, very tall, like 20, 30 feet tall. So there's no way to buffer the sound. So yeah, there's that. But yes, I have every Keanu poster up. I look like a teenager lives here. I'm not sure how I like the place yet. I have been very sad since we've moved in here because it is very isolated. But we're here now. Realized a couple things when we moved in. We don't have a freaking microwave, so we had to buy a microwave. How weird is that, right? Like, where do you move now that doesn't have a damn microwave? Yeah. So, we had to do that. And then our landlord, she was like, they were going out of town for 2 weeks, and she has geese down on her part of the property. And I was like, oh, who's taking care of your geese while you're gone? And you know what she said to me? She said, oh, yeah. So the girl before you that lived here, she used to do that. I was like, oh, okay. Uh, uh-uh. Uh-uh. Not the one. Not the one. So you don't know me. That's yeah. Unless I'm getting a deal on my rent and actually ain't even nope, I'll just pay my rent. So ain't doing the geese thing. Yeah. Yeah, I'll just tell you this. Do not look for a place to live while you're in the midst of having a nervous breakdown, because then you end up out here. Yes, they did. Yeah, they did some it was pretty bad. It's pretty bad. I will say, I think that it was definitely an overreaction over some possible bottles of water. Okay, I'll just say that. And I will say that regardless of the kid having a gun. Regardless of, this kid probably would have ended up who knows where with his lifestyle choices. I think it's a very sad situation for everybody all the way around. And I think that unfortunately, there's not going to be any winners come out of this situation. I don't think that they should be charging him with what they're charging him with. I think maybe reckless. I don't know. I don't know what the options are for what they can give him, you know. But I don't think he had any malice or anything like that. And no one knew the kid was 14. I mean, I know they're talking about him being 14. I think it's really sad that he was 14, but I don't think anyone knew. No one knew he was 14. So and Columbia, South Carolina is not a very nice area. It's actually really gross. I used to live in that, I had that market, so it wasn't the greatest. Yes, they are charging him with murder. So it's really sad. I don't know why they go to like the harshest penalty. But they, you know, the guy's family has been destroyed. I mean, obviously the kid's family, you know, he lost his life. And okay, let's see, they're back. I mean, he did take someone's life, and they are responsible. They did go after this kid over bottles of water. My gosh. I mean, in his defense, he came in after the fact. His son was the one that was going after the kid for what he thought the kid did, stealing water. So the father, who's being charged with this full-on murder charge, he came in thinking that his son was in danger. So, I mean, he really didn't have the full story. He came in after the fact, and he really did think that that guy stole something. So in his mind, he thought the guy stole something, and he saw a gun, and he thought his son was in danger. So he didn't have all the information. So it's a terrible, tragic situation. But I don't think this is the correct charge. I think recklessness, you know, it's kind of like when you go into a situation without having all the information. Like somebody said some stuff about China, and I'm going in there, I'm gonna whoop your ass. And then it turns out they didn't say shit about her. Oh, my thing just fell down. Oh, shoot. Dang, that scared the hell out of me. Right, but you know, China, if somebody was saying something about you, would I care if they was running away? No.
First was they needed waters and coats, so we've gotten that taken care of through the bales. Second,
Oh, does it?
how does one?
The owner? Well, it says he's gotten into fights with them.
As yesterday, 4 hours. Hour and 15, hour and a half break for lunch.
I hate when people say that. I saw it said he's gotten into fights with other people before, but not shot anybody else.
No, sir, I just based upon that for scheduling purposes for this witness. I think they would particularly know how long we're going to go.
He's just willy-nilly shooting people.
Okay, it'll be lengthy. No, just see what time the court will break, so we can have like a window when we would be breaking.
Your Honor, it seems like you normally take a 1 o'clock lunch.
I tried to take it around 12:30. I was sort of anticipating you say this is lengthy, break after the direct and cross after.
But I'm not.
Oh my gosh. Did y'all hear about that lady that shot those 2 attorneys in North Carolina?
We have
Raleigh?
after we're done with this direct and break, and then we'll cross after lunch.
Yeah, we'll just see where we are.
Can we vote for a quick
Yes,
second?
sir.
Isn't that crazy? At first, I thought she did it in the courthouse, but she did it outside the courthouse because I was like, how the heck did she get a gun in the courthouse? I think this is just a very sad, sad situation. I think this is terrible. I think they did survive, but I don't know to the extent of their injuries. I know they had to go into surgery. Oh no, did she? Oh dang, China. I hadn't heard any after information because I've been moving, but I didn't hear. Oh my gosh, that's sad. I don't even know what she was it like over some kind of state issue or something is what I'm just guessing. I don't know. Yeah. She was caught because she was the defendant, I guess, for lack. She was going against their firm. I want to say it was like an estate thing, but I can't remember. I honestly, I don't know. I just think it didn't go in her favor in court. She got upset about something. They got lots of lawyers. Holy moly. Well,
You're a citizen, Your Honor.
That's just told. All right, ladies and gentlemen, I received your note. I'm informed that you were provided some refreshments. So I think they also.
and today Carly Gregg is appealing her. She's going for a new trial.
You typically try to take a break for lunch, excuse me, depending on the witness schedule.
Any minute now, actually.
We'll take about an hour, 15 hour, 30 minutes, because I know you all have the process of getting parked and getting in through the metal detectors and all that good stuff. But we'll looking to try to break today for lunch around 12:30, sometime that day. So, no, I'm not gonna make it work for lunch like this. All right.
Oh yes, so they're coming in right now for Carly Gregg. They're doing the appeals court. There's six judges.
Do you swear or affirm the testimony you give this case to the truth and whole truth and nothing but the truth so help you God? Thank you, that seat the witness stand and state your full name for the record.
I think she might get a new trial, but it'll be like a couple of months before the decision comes out.
Okay, Mr. English, where are you employed?
Right now, the Great Falls Police Department.
Okay. Chester County?
It is Chester County, yes, sir.
Back in 2023, where were you employed?
Richland County Sheriff's Department.
Okay. And what were you, a deputy, road deputy back then?
I was on patrol, yes, sir.
Okay. Do you recall the night of May or the late afternoon of May 28, 2023?
I do. I was working on shift that night.
Okay. What were you up to around 8 o'clock?
We're dealing with a few individuals who broke into an apartment off of Ranch Road, and then I was dispatched to 7441 Parkland Road.
Okay.
He's
So you're dealing with, what'd you say, a break-in of some sort on one part of town. And then you said you're dispatched to 7441 Parkland.
Yes, sir.
Okay. And what was that in reference to?
The Parkland call,
Yes, sir.
in reference to a shooting hit. So someone that got shot.
Okay. What is that 7441 Parkland Road?
That is the Shell gas station.
Okay. Is that Richland County?
It is, sir.
Okay. Is that where you initially responded?
I did, yes, sir.
Okay. Let me ask you.
Oh, okay.
Generally,
I was like, dang, China.
orient the jury. That location, that Shell gas station, 7441 Park Lane, it sort of sits at the corner of two roads. Is that right?
Yes, sir.
Okay. We obviously Park Lane Road,
Yes, sir.
and then what is the road that cuts up beside it?
The secondary road is Spring Tree Drive.
Okay. And Spring Tree Drive, does that dead end at some point?
It does. It goes into an apartment complex called Willow Oak, if I'm not mistaken.
Okay. Let me show you a number of pictures that sort of show that area. This is states 14 through 31. Tell me if you just generally kind of recognize what these are.
You want me to look at all
Just look through them and I'll ask you a question after you review them.
of them? Okay.
Oh, Lord. Stealing SNAP benefits.
Okay.
He is
Do you
adorable.
recognize those?
I do.
Those generally depict that area we were discussing, 7441 Parkland and then Spring Tree Drive right beside it.
Yes, sir.
Okay, Spring Tree, you talked about it dead ending at some point. I mean, some parts of it. How would you describe Spring Tree Road?
Shut up, China.
It's a road that goes to a dead end.
Oh, he's
There's
cute.
3
I don't even know what he's
apartment
saying.
complexes. 220, 250, and then 100. Willow Oak Drive.
Okay, is it a hilly road? Is it a wide
Old
road?
enough to be
Is it
his
a
mama.
road? Is it a flat road?
It's pretty flat.
Okay, is it a curvy road? Is it a straight road?
It's a straight road, like a straight shot.
Okay. Now you said the call for service had you going to
Yeah, I just went
7441
over there.
Parkland Road, which is that Shell gas station. Were you directed elsewhere after you arrived on scene?
Yeah, so when I arrived on scene, stepped out my patrol vehicle, I was flagged down to go slightly further down towards 220 Spring Tree Drive.
Okay. So you go to the Shell gas station and then later you're rerouted up farther up the road.
Yes, sir.
On Spring Street. And then you went immediately to where you were directed to go.
Yes, sir.
And what did you observe once you got there?
Observed Barrel Mike, our black guy, laying on the ground with a bystander doing chest compressions on the individual, and multiple witnesses just standing by.
Okay. Did you later learn who the black guy was who was on the ground?
Later. Yes, sir, I did.
At the time, did you understand him to be the victim of the shooting that you were responding to?
Yes, sir.
Okay. And you said he was, medical aid was being rendered on him when you arrived, is that correct?
Yes, sir. That's correct.
Okay. And so what do you undertake to do once you arrive on scene?
I just told the individual continue to do chest compressions due to EMS being like 10 seconds away.
Okay. Were you first responder?
I was first deputy on scene.
All right. It's kind of state does all for their identifier. It's going to be states 14 through 31 for admission and evidence.
Yeah, she was right. She was only 14.
All right, I think it states 14 through 31 without objection.
And permission to go ahead and start publishing.
Yes.
I just want to orient the jury. Do you mind just kind of explaining some of these things if I put them on the screen?
Yes, sir.
Okay. Stephanie, can you have states 15? Okay, Deputy English, do you see states 15 there?
I do.
All right, if we're looking at states 15, we're looking at the right side of this photograph. What road is that we're looking at?
Like the one that goes up and down, correct? All right, that's going to be Park Lane.
All right, and that red roof structure is what?
That's going to be Shell gas station.
Okay, the road that cuts between from Park Lane
I don't think she should get a new trial.
Goes to the left of the picture is what road?
Spring Tree Drive.
Okay, and that's what you were describing now, right?
Yes, sir.
And these are the apartments we see the roofs of. If you
I don't think she should be in solitary. I don't think anyone should be in solitary for
on the left side, you see some
Along
swimming
that
pools
long.
and whatnot. There's the apartment complex that you're talking about.
Yes, sir. That would be 220 Spring Tree, and then a little further down would be 250 Spring Tree.
Okay. And so your testimony is you arrive at 744 on Park Lane and you're directed farther down Spring Street.
Yes, sir.
So you're talking about this being Park Lane, that being the Shell gas station.
Yes, sir.
Where you arrive, and then you're directed down this way, down Spring Street?
Yes, sir.
Okay. And you see generally where you found a victim of a gunshot wound in this picture?
Yes, sir. So if you look where the little wooded area is, so bring your little stick, yeah, about right in that area right there.
Okay. And that's where you were talking about seeing, you call him the black guy. Do you know him now to be Cyrus Carmack-Belton?
I do.
Okay. And he was lying on the ground. You said people were rendering aid to him.
One bystander, yes, sir.
Okay. Did you also see the defendant, Mr. Chow, at the scene at that time?
I did.
Did you understand who he was when you first arrived?
Not at all.
Okay. What were you doing? I mean, were you securing the scene? Were you collecting evidence? What exactly were you doing?
So one was trying to secure the scene. I was informed that there was a weapon on the ground, so I wanted to secure that in the back of my vehicle.
Yeah, I think they should keep her in juvie until she's 18 and then bump her up to, but I don't think she should be in solitary because that's brutal.
When you left the 7441 Park Lane to go to where the victim was, did you walk up the street or did you drive your car up the street?
I drove my patrol vehicle.
Okay. How would you describe the distance between that?
I think
Shell
what she
station
did
and
was
where the victim
definitely
was found on the ground?
calculated.
I was at about 130 yards.
Okay. I mean, would you describe that distance as being significant in any way, or why did you walk from the gas station up to the?
It seemed pretty far.
Remember me showing you some drone footage that sort of shows a video going from the gas station up the street to where the victim was?
Yes, sir, I did.
And did that fairly and accurately depict what you yourself witnessed whenever you drove from the gas station up to where Mr. Belton's found?
Yes, sir.
This is state's number 2. Do you recognize that in the drone video?
I do.
Now, the state does offer state's number 2 for admission.
Objection.
Come on,
I mean,
Subject to conversation, no objection.
All right, be admitted as states exhibit 2.
Okay. And permission to publish?
Yes, sir.
All right, before you start, Stephanie, all right, what are we looking at right here? Just, and I hate to keep belaboring the point, but I want to orient everyone with what we're looking at here. We're looking at this first shot, stage number 2. We're looking to the left. First of all, is that the Shell station at 744 in Park Lane?
That is
All right. Now, Deputy English, if we're looking back this way, that would be Park Lane, right?
correct.
Okay. And in this road right here, we see a couple of cars on the side. That would be Spring Tree.
That is correct.
And of course, Shell gas station sits on the corner, Park and Spring Tree, which you already testified.
Yes, sir.
Do you recognize this as the front entrance to the gas station?
I do.
Okay. All right. Give me play. Okay. Press play.
I was like, why is this moving so fast? It's a drone. So is this where they chased him? Flash followed.
Okay. And where we end on that video, is that essentially where you found Mr. Carmack-Belton?
That is.
May 28th, 2023?
Yes, sir. That is.
Okay, and that accurately depicts the pathway you would take to get there from the gas station?
Yes, sir.
All right. You talked about seeing Mr. Belton and aid was being rendered. Do you remember the fire department showing up?
I do. I remember EMS and fire department showing up.
Okay, you remember EMS showing up. Do you remember eventually Mr. Belton being taken away in the ambulance?
I did.
Okay.
Yeah, I mean,
At this point,
well,
he's being taken care of. Does your focus shift to crime scene integrity?
It does.
And so did you put out crime tape and whatnot?
I did.
I guess he wants cake.
Uh,
Let them eat cake.
And a crowd started to gather at that point, or were there people on scene other than Mr. Chow and Mr. Belton?
There was just bystanders, some who heard it, some who witnessed it.
Okay. And did you at some point try to speak with some of them?
I did.
Okay. At some point while you're out there, did you begin locating evidence?
I did.
Okay. You remember a backpack?
I do. A black backpack.
Okay. And where was that?
Like in you can't see it from the picture,
We'll go back to the number 2. Let me see if we can.
but it was located in a drainage ditch.
And I'm gonna get to it in a minute, but you're yeah, you see, all right, this is this is state's number 26 that's been admitted into evidence. Yeah, so you can see it. 26. All right, do you recognize these two poles right here?
I do.
Okay. And do you recognize this stand of Bradford Pick, these trees right here?
I do.
Okay, would you agree that where I'm pointing this pointer is essentially where Mr. Belton's found?
That is correct. Yes, sir.
Okay. And the drainage ditch you're talking, or the drainage, I guess, how did you describe it?
I call it a drainage ditch.
Okay. Is that what you're talking about right here?
I am.
Say again?
Yes, sir.
Okay. And what did you say you found down that drainage ditch?
Black backpack.
Okay. And did you come to understand who that belonged to?
At the time, we didn't, but we later found out who it became.
Mr. Belton?
Yes, sir.
Or was associated with him somehow?
Yes, sir.
I mean, you collected?
I did.
Okay. What else in this general area that we're looking at, states number 26, did you locate?
Shell casing,
Okay.
and then a tactical light.
Okay. Were you wearing a body worn camera at the time?
I was.
Okay. You saw a tack light. What is that?
It's a attachment that you can put on a firearm,
Okay.
like a pistol.
And it's something you would, manually put on a pistol?
That is correct.
Are these common or uncommon?
Pretty common for people who shoot, I guess, towards the nighttime.
Okay. And what do? They provide like a flashlight. Some have like a laser too to help with accuracy,
Yes, sir.
help with vision. Do you own pistols with tack lights?
Me personally?
Yeah. Or have you ever been issued one, or have you ever?
At the sheriff's
operated
department.
one?
Yes, sir.
Okay. And you say they are not uncommon.
That's not uncommon.
All right. What else did you find? You got the backpack. You got a tack light, and the tack light was attached to a gun or not attached to a gun?
It wasn't attached to the gun.
Okay. And it was just lying somewhere in this vicinity here.
Yes, sir. It was located near the shell casing.
Okay.
Also located.
So you found a tack light and you found the shell case.
Yes, sir.
Okay. And did you mark those in any way?
I did.
You said, started to ask you at least, you had a body worn camera at the time?
Yes, sir.
And it was operational?
It was.
Okay. Let me show you states number 1, see if you recognize this.
I do.
Okay. And does it, now with the exception of the court, the state and defense is muted portions of it.
Okay.
And you watched that earlier today?
I did.
And aside from that, the agreement by everybody that portions would be muted, does it fairly and accurately represent what you yourself witnessed?
Yes, sir.
May 28, 2023.
Yes, sir.
The subject of yesterday's ruling is objection to states number 1. And we've also been given states 32 through 43. No objection.
32 to 43.
Yes, Your Honor, 32 through 43, which are still from state 1. If you want that up there, I'm sorry.
All right. Now, the state at this time offers states number 1, permission to evidence, permission to publish.
Subject to yesterday's pretrial motions and will be admitted as state 1 without objection.
Hey, where's he at?
Marcy's so crowded.
Hey, EMS is right here. Okay, keep doing compressions. Keep doing compressions. Okay. Still doing compressions. Okay, yes, sir, I see that. Okay. Keep doing compressions, man. The EMS is right there. Hey, y'all stand back. Stand back. gonna need your information since you were doing compressions. How long were you doing compressions for? 3 minutes? All right, cool. Hey, just don't cross it. But thank you. Ready to walk through. 59 is in the back of my trunk. You hear me? 59 is placed right here is in the back of my trunk. I go down there, Sarge. I got it. You see it? I got it.
Ooh, all the kudzu. I do not miss kudzu.
Let's hang up. You want to go get that one?
There's 6 judges when they're on. I don't know why they're only showing these 3, but there's 6 total judges.
Are you the one who shot him? What's your idea? Hey, sorry, I got store clip right here.
And they get a certain amount of time to argue, prove their case, and then the judges start asking them questions. Yeah, they get 20 minutes to begin with, and then and the judges start asking them questions.
Sit right there. Sit right here. Sit right here. Sit right here.
I was just walking by and then I seen him over here with them, and I was like, oh, he looks unresponsive, so I came up with like something.
Where's the sun at? Yeah, Carly's attorney's not saying anything that makes any sense. He's not giving a good argument. That Murdaugh appeal was freaking amazing. This guy sucks. Yeah, it's bad.
Don't let me forget I have your ID.
She needs Murdaugh's attorney.
Yeah, I know. Hey, sir. Sit at the back of my car. Do not move. Thank you. Hey, Mel. I need y'all to get in the street this way. I'm trying to do a picture, but I need someone else right here. Open this up, but she wants that. Hey, that's a black plate. Sorry, it's a tag light. Come on,
Yeah. That's where you were noticing the tack light right there, you're pointing to it.
Yes, sir.
Okay, and then did you do anything to mark it at the time?
We did. I want to say like a card.
I'm not stopping again, but after that, is that about whenever you find the shell casing and you point it out and mark that as well?
Yes, sir.
Even the lights are. Thank you.
Dang, if he shot him from all the way back there, this might be a different story. Yeah, this is a different story because his body was way up there. If he found the shell casing way back here, that's a different perspective.
Stay right there. You guys are, come on, keep going, keep going.
No, they ran. Remember, he ran out of his shoes. He ran so fast. But now I'm looking at the shot angle. This is different from where he was given CPR was under in those trees. The shell casing is found down here, so that puts it in a different. That means he was way farther back where he shot him. So that yeah, that's a different story there.
And I promise you, okay, we'll get to you, okay? Thank you. Sorry, I need your voice. Do not cross this tape. If y'all cross this tape, sorry, don't pick up anything off the ground either. If you cross it or pick up anything off the ground, I'm charging you instruction.
Yeah, this is a little different. See, we always gotta wait till the evidence comes out. Opening statements and closing arguments are not evidence. That's right.
Yeah, that is ideal. Actually, I haven't ran yet. I'll get him down for you.
Don't just go chasing people down like a crazy person. You never know what'll happen.
went down there to do something, and he came back. I didn't know he was a suspect or what. So he's been there. We have this hack laser, and we can tap that right here, and then we showcase him. Looks like a 45.
Yeah, see, the shell casing's all the way down there. That's questionable right there.
But it is weird because that's the one who did compressions. That's her who did that. Apparently, this is getting their information. Did you ever get your information to the other deputy? Your ID? Okay. Thank you.
Oh, that.
Because the rounds that's in there doesn't match. So you probably have to look at it. They didn't have it. Not me. See? Yeah, that's what I got out from my I think that's just my technique. Yeah, sure. It looks like 45. I don't think the backpack has it at all.
Well, we gotta get, when the expert gets on the stand, we gotta see where was he standing. Okay, so where's the ambulance at? I need. Where was the body? You know they ain't already taken his body that fast.
You want my statement? I can tell you what happened. He shot me in my store. I said, I followed him up. I followed him. On the way down here, we told him to drop. I think it's a train song. I think he probably he should just not get and then right about my son saw a gun in his hand. He's got a gun. So I told my brother, couldn't drop it. He continued to work with the gun. And my son, he's calm. I was behind them. They were going to drop it in my face. So I fired one shot. You can find 45 shots. Yeah, I fired one shot. So the shooter is my gun. He's not going to say nothing. He's like, why did you fire a shot? He's my assault. I didn't say it initially. So when I
I need to see the distance. I need more detail. Oh yeah, you can't shoot them while they're running away. So you got to get them while they're in the house, or drag their asses back in. Mm-hmm. You can't get them while they're running.
Yeah, so that's the suspects. I think it's on that ticket. I actually moved
Yeah, you gotta get them while they're in there. Or if you don't, you better drag them back in there. You gotta make it look like they was in there. They better be over the threshold. No, you just to be on the safe side. You pull them over the threshold.
As far as law enforcement's concerned.
Yes, sir.
Notice there was some confusion.
You're gonna be in my house.
Whenever you find
I'm gonna make sure.
the gun, when you first arrive there,
It was coming right at me.
seize that weapon. Okay, and then you find the casing, and there's some confusion because you say, the skunk dollars. Yeah.
Yes, sir.
You had not yet seized the gun off of Rick Chow at that point.
No, sir.
Okay. Let me show you states 32. Is this just kind of a screenshot from your? This is our screenshot of your body camera.
Yes, sir. That's when I originally went on scene.
Yeah, I need to see the expert witnesses lay this out because I'm feeling like the way I'm picturing this now is that this kid was running and old buddy was like literally like in a stance and just like shot him. That's how I'm picturing it now. I'm not even picturing like self-defense or anything. I'm just picturing he's just like boom and like he had time. He's like, stop right there. Boom. That's how I'm thinking. Just based off where the shell casing was and where he ended up.
State 32, please.
Dude looks like Ron White. He needs to have a glass of whiskey in his hand.
All right, this is just a screenshot right from your body cam that we've already introduced.
Yes, sir.
This right here, that's going to be the 9mm that you collected initially.
Yes, sir.
All right, this one, I give a great latitude and object and lead and understand that the state has a right to establish this, but the witness can come down and give him the stick and he can cannot just, I'm concerned about relaxing into leading. Most of this has been foundational thus far.
We're just trying to move it along. You already.
Yeah, I overrule the objection. I understand, the rule 611 does allow limited leading to develop witnesses testimony.
Okay. We watched the body cam earlier, right?
We did.
And we saw you collect everything. And let me just ask you, what is this black item here?
A firearms pistol.
Okay. When did we see that? When did it go on your body cam?
When I first arrived on scene.
Okay. And what did you do with that black object?
cleared it, rendered it safe,
Okay.
placed it in the back of my trunk.
This is state's number 11. You recognize this?
I do.
Okay. What is that?
The firearm that's in this picture right here.
Now, the state offers state's number 11 for admission of evidence.
Carmack-Belton states,
You roll objection on it, there's just not a gun lock or anything on it yet, so before it's submitted. Just for safety.
Would be admitted as state's 11.
And if I may ask, who do I address with the defense for this witness? That,
Oh, jury instructions are terrible. Yeah, that's the problem in a lot of cases. That's why they're getting thrown back out, is because the jury instructions, the judges are just awful. I mean, look at the judge in Josie's case. She'll get a new trial because the judge couldn't even string one sentence together. And I think Josie's case will go back because her trial was just such a circus. This case can't even get through the first witness. This should be easy peasy. You're the first guy on the scene. My gosh.
All right, Scott, you ready?
okay.
I don't remember the jury instructions in Carly's case,
9mm,
actually.
and that was number 11.
I'll have to go back to my videos.
Took it back to the car and secured it.
Yes, sir.
Saw on the video a tack light. Okay, let me show you state's.
Yeah,
number
she has no parole. I know she has no parole.
6. Tell me if you recognize this.
The judge was very, very hard on her. She ain't never getting out.
Okay. Stephanie, would you put up states 35? He had identified, but I'm all for states number 6 for admission of evidence. 6.
Objection. All right, be admitted as state 6 without objection.
All right, in this picture, see those markers on the ground, Stephanie? This placard right here is.
Well, she waived her right to parole.
Evidence is a crime scene marker. Okay, right, evidence marker.
But I don't think she understood. She's 14.
Oh, exactly. I apologize. It's that-
And I don't think her lawyers explained that very well to her.
States number 6. Correct. Okay, and let me have 37. Okay. do you see, you talked a little bit earlier about a drainage ditch. Did you see the drainage ditch in States 137?
I do. Bottom left-hand corner.
This little area here?
Yes, sir.
Okay, and then AA, you just said it's a tackway?
Correct.
All right. Stephanie, we have 38. All right, what is this? Do you see the tackway in this picture?
I do. This is before the markers were placed.
Okay. Well, in the body cam, it showed you throwing some pads and stuff down. What were you doing there?
So just due to me not having anything in physical possession, I just threw down my notebook.
Who puts those placards down later?
The yellow ones?
Yeah.
Crime scene.
Okay. You recognize this item here in States number 38?
I do.
And what is it?
That's a tack light.
What is States number, let's see, go back, Stephanie, to 35. What is, in States 35, what is that placard AB? What is that marking?
The shell casing.
Okay. And do you remember on your body cam when you located it on that video?
I do.
Okay. Let me show you States number 7. Well, you might not be able to identify, but do you remember it being there?
I do. That's my notebook mark.
Okay, States number 7, I'm just gonna get you to identify. What does it look like?
It's labeled as 45 caliber FFC. I'm sorry, FCC, or fire casing, shell casing.
Does it list the marker?
It does. This is marker AB. Brown.
So, but you yourself didn't collect that casing, you just identified it and let crime scene pick it up later?
Correct.
Okay. Noticed on there, were you present whenever the firearm was finally located on Mr. Chow?
Once I walked up,
Okay.
yes, sir, and they were taking it off.
Okay. This is States number 10. Just look at it, see if you can recognize it.
I do.
You recognize it?
I do.
Okay. And was that, what was that?
It says Glock 45 caliber on there. I think the model was a Glock 30.
Do you recognize it as the weapon that you yourself saw being seized from Mr. Chow that night?
Yes, sir.
I don't think anyone should be in solitary confinement.
Okay, so
Unless it's just for their safety,
the
but
scene was,
still a long period of time in solitary is
Mr. Belton's taken away.
dangerous. I mean, you just start to lose your mind.
Ran the firearms, created a crime scene log, and just waited by for a crime scene. Informed the desk sergeant of what happened for the incident.
Did you ever have a chance to go back to 7441 Park Lane?
Yes, sir. Myself, along with other investigators, walked over or drove over, one of the two, to look at the surveillance footage.
Okay. Did you go with Investigator Jordan?
I did.
All right, and was your body worn camera on at that time?
It was.
Okay. And was it recording?
It was.
Okay. Great.
I think that the prosecution saying that Carly waived this and Carly waived that, she was 14. I don't think she knew what she was doing.
Yeah. Okay. states 49 through 52, where we left off, and I know we're trying to get through a bunch of pictures, and I'm skipping around, but after you cleared the scene, we talked about the evidence of the scene, crime log and everything. Then you go back up to 7441 Parkland.
Correct.
Body camera's still on.
Correct.
Did you go in the store?
I did.
Okay. Were you able to further talk with Rick Chow?
I was.
Okay. And was Alice Chow there?
She was.
Okay. Who else was there?
Andy Chow, if I'm not mistaken.
Okay. Were you or were you not able to go back and review video with Rick Chow?
I was.
Okay. And was that filmed on your body camera?
It was, yes, sir.
Okay. And were you with investigator Ty Jordan?
I was.
Let me show you states 49 through 52. Tell me if you recognize those.
This is a very scattered
This is us looking at the security
question
footage.
answer.
This is multiple cameras on the screen. This one shows inside the store with Mr. Cyrus. This is a zoomed in shot of Mr. Cyrus at like a cooler,
Okay.
I guess you can call it. And then the last photo is us talking with Mr. Chow and his son in front of the cash register.
Okay. All right, you're on the state hall for states 49 through 52 for admission and evidence.
Yeah, the 52, just the original objection as to 52 from yesterday's pretrial hearing. Other than that, no.
All right, they will be entered as, or admitted rather, as states 49 through 52, subject to objection yesterday.
Okay. Tell me about, was there anything, what was it, a convenience store?
It was.
Was there anything noteworthy or anything that you noticed when you go in the store?
So as soon as you walk in the store, besides the normal gas station stuff, once you walk up to the counter where the cashier is, I mean,
Yeah, she's
different
evil.
things up there. Lottery tickets. At the top, there's like the wall of shame. And it's pretty big. There's multiple people that's been in there prior.
Okay. Let me show you stage 52.
Oh my God.
We already seen it, but let me publish it. All right, first of all, who is this individual in stage 52?
That's Investigator Jordan.
Okay. Is he here in the courtroom?
He is.
Raise your hand, Jimmy. Okay. And this is who?
Mr. Rick Chow.
Okay. Do you see Rick Chow here today?
I do.
Okay, where is he?
Sitting at the table over there.
And this is who?
Mr. Andy Chow, his son.
All right. And this, what is this? Is this what you were just describing as the wall of shame?
Yes, sir.
Oh, they have a wall of shame.
So you're there and you clearly,
I love
this is
it.
your body cam.
I've worked at places that had that.
At some point, while your body cam's running, go back, you said it to the, where is the surveillance room? I guess with the cameras on.
Like behind the counter and like a little office space back over there.
Okay. Show you states number 49.
I think they should study her.
All right, where are we looking?
She's in solitary. Like, why aren't they
We're
trying to
inside
figure
that
out what
office space.
went wrong in her mind?
Surveillance footage.
All right, and whose head is that we see?
Mr. Rick Chow.
Okay. Do you know, all right, what are we looking at on his laptop with the record in front of him?
Multiple cameras, surveillance footages.
Okay. And there were a number of different camera angles, is that fair to say?
Yes, sir.
Okay. And is that what y'all are reviewing here?
Yes, sir.
Let me show you states 50. All right, what are we looking at here?
One of the actual cameras, and then in the far right, top right side of that camera is Mr. Cyrus.
Okay. Liz, tell me about Mr. Chow. Was he able to demonstrate different capabilities with his surveillance system while you were there watching him?
Yes, sir.
All right? Such as,
He was able to find what area go backwards on when the individual walked inside, when he was walking around, when he walked outside, just any camera angle we needed to look at.
so he was able to access these different camera angles while you were there watching?
Yes, sir.
Was he able to reverse,
Yes, sir.
fast forward,
Yes, sir.
blow it up, make it bigger?
Yes, sir.
He was able to do all that?
Yes, sir.
States 51. What do we see here?
The photo, the photo from before, but zoomed in.
Okay, so he's actually taken the angle we saw before, but zoomed in on it.
Correct.
And then you were able to watch this particular video play out in front of you.
Yes, sir.
Yeah. As far as states 51 and what it's depicting here, that video, that angle, what did you all discover when you watched it?
Mr. Cyrus, I think, grabs several waters from that cooler and then places them all back
Okay.
as if he decided he didn't want them anymore.
Okay. Well, is it safe to say that this is kind of the moment that y'all realized he never took anything?
Yes, sir.
I don't think she hated either one of her parents, which is really weird.
And all these, you've been able to watch a lot of these surveillance videos since then.
I would assume so.
And they were seized. Do you understanding as far as
I
you
understand it. Yes, sir.
All right. States 3. Do you agree that that's the surveillance videos taken from the Shell gas station?
I would agree.
I feel like this trial is in slow motion.
The state offers at this time, states number 3 for admission of evidence.
Well, it seemed like it was perfect.
To be clear, we're not publishing your report. Yeah.
Oh my gosh, what in the devil? I don't know. This is like the slowest turtle pace. They're still on the first witness, the first cop on the scene. This is so now I'm starting to question China. Where they found the shell casing and where they were doing CPR on the kid. Oh, it's kind of suspect. This is weird. I'm beginning to wonder the distance. How much self-defense is involved here?
He's admitted as states 3 without objection at this point.
So I don't know.
Yeah.
Okay. But I will note for the record that
I need to see some more.
reserve the right to object on publication.
Yes, sir.
But Cutie Pie's still on the stand because he can't get a question out and an answer out.
Deputy. Who at the scene on the night of May 28, 2023, who ever said anything about Cyrus pointing a gun?
Nobody.
Nobody. You were the first to talk to him.
Yes, sir.
The testimony under oath is nobody told you that night that Cyrus pointed a gun at him.
Yes, sir. No one told me that.
And in your body cam, when you talk to Rick Chow, what does he say? Does he say he ever saw a gun?
No, he said his son. See that gun?
Okay. What, if anything, did he say about Cyrus trying to run away?
He just said that he failed, kept running.
Okay. And then what did Mr. Rick Chow do as Cyrus was running away, in his own words?
He told him to drop the weapon, then proceeded to shoot one shot or fire one round.
Okay. And I noticed at some point he left the scene. Do you know where he went?
I don't know where he went. I can assume he probably went.
Well, don't do that.
All right.
He left the scene.
He did.
And we see on your body cam when he's coming back up to where Cyrus is, and you speak with him.
Yes, sir.
Speak a little louder.
All right, let me ask you again. On your body cam, we see you approach him as he's coming back towards the scene. We know he's there when you get there.
Mm-hmm.
But at some point, you're able to meet him as he's coming back from Park Lane towards the scene.
Correct.
Okay. And at that point, it looks like you're telling him to stay put. You want to speak with him when you get a chance.
Objection on reading.
Let me rephrase it.
Just rephrase.
Explain, if any, difficulties you had as far as having witnesses stand still and stay put. Do you remember anything about that in your body cam?
Yeah, I remember telling Mr. Chow to stay by my vehicle.
Okay. How many times?
Multiple. He kept moving around, so I kept instructing him to stay where he was.
Anything else that you were involved with that night? Evidence, at the scene, and then going back to the Park Lane and operating a body worn camera. Anything else you remember?
That's it.
All right, I'll just remind you, you talked earlier about the backpack, recovering it. This is states 12. Stephanie, can we put 33 up?
Well, you're already shown it. This is like the longest freaking questioning. Holy moly, bajillion.
You recognize states 12?
I do.
What is it?
Backpack, of course.
And is that the same backpack we see in states number 33
Yes, sir.
that you recovered from that drainage ditch?
Yes, sir.
Now the state offers states 12 for mission.
No objection.
Be admitted to stage 12 without objection.
I just want to make sure I haven't forgotten anything. Let me ask real quick, but I think I'm winding down.
Lord help us. This trial's going to go on for a month at this rate. Why is he asking the defense? What? That's unusual.
You identified them earlier. States 10,
That's weird.
states 7.
Yes, sir.
State 7 was what?
The shell casing.
The marker AB.
Yes, sir.
10.
Firearm from Mr. Chow.
The state, this time offer states 10, so for mission evidence. Real quick.
All right, stage 7 and 10 will be admitted without objection.
Only other thing that I think of this sort of left out, do you remember?
I have never seen the prosecution ask the defense if they forgot anything. This seems more discombobulated than the Josie trial.
What if anything, you know how, there's timestamp on your body worn camera video?
Mm-hmm. Yes, I'm sorry.
What if anything, and I'm looking even at States 52. Did you notice anything about the timing when you were viewing the different cameras and camera angles within the gas station as far as times associated with those videos?
Yes, sir. I realized it was off by a few days as well as the time was off.
Okay. So the times and dates on some of the cameras from within the gas station didn't quite match up.
Yes, sir.
I had another stack of pictures I meant to.
Oh my word.
They hid from me my podium. This is 44 through 48, just quickly. Look at those, just tell me if you recognize them.
Is this guy an attorney?
I do.
Okay. Sorry, you recognize those?
I do.
All right. As far as states 48 and 47, what are we seeing in those pictures?
2 cell phones.
Okay, where are those located?
Right now? in
Where
our
were
picture?
they in this picture?
No, on the counter.
Where? Where was the counter?
Oh, inside the store.
Okay, gotcha. What, just a white and black cell phone?
Yes, sir.
You know, state officer. States 47 and 48 for Michigan government.
47, 48. No objection.
All right, stage 48, 47 and 48 will be admitted without objection.
States 45 and 46, what do we see here?
You see a white shoe, almost like an Air Force One,
Okay.
located within the store as well, next to the counter where the phones are located.
Okay. States 45 and 46 for Michigan.
No objection.
All right, that'll be admitted to stage 45 and 46 without objection.
States 44?
Oh, that's the inside the store.
Okay. And that just, is that
Judge,
okay?
you do have an objection to that. Publishing it either. Pre-trial motion.
Oh, okay, yes, but, what number was that, Mr. Scott?
44.
All right. Go ahead.
Just fairly and accurately depict how the store looked on the night of May 28, 2023.
Yes, sir.
State officer states 44 for Michigan.
Be admitted to stage 44, subject to the pre-trial judge.
Deputy English, please answer any questions that Mr. Swerve has for you.
I think we're gonna break for lunch at this point.
I know, he's the judge is like, oh my Lord.
All right, ladies and gentlemen, we're gonna break for lunch now. It is 12:40. Let's be back here at 2 o'clock.
2 o'clock.
Get started soon thereafter. Again, don't discuss
Oh,
dates,
and the appeal court is on break as well. So,
or anything of that nature, and we'll enjoy lunch. We'll see you back at 2 o'clock.
appeal court is on break. Okay, that was torturous. That was pure torture. If I was on this jury, I would literally just want to gouge my eyes out. Are they going to give a verdict today? I thought the appeals court doesn't give a verdict the same day. I thought appeals court, they wait, they actually have to like take all this information into consideration, and then they actually don't give a verdict until for a couple of months. I mean, because like Alec Murdaugh's didn't come back for a couple of months, and we still haven't heard one for like Michael's took a couple of months to come back. Yeah, that it's over. They won't come out with a verdict for the verdict won't come out for a couple of months. They'll have to take it all into consideration, and then they'll come out with their decision. So yeah, no, they won't be back today. It'll be months from now before we hear anything. And then we have I know they are doing the Delphi guy. They're trying to get him a new trial. Yeah, because the live part is over. So yeah, they don't think Richard Allen did it. I always questioned, to be honest with you, I always questioned if Richard Allen was really the guy. They didn't have any real evidence against him. They didn't have any. Once again, they didn't have any evidence against him. I think they convinced him that he did it. I think that they made him falsely confess. That's what I think. And this whole like Odin theory, yeah, I don't know. I don't know about this whole cult thing. I don't know. I honestly am not sure how yeah, I think because he was in solitary confinement, because he really did claim his innocence. He stuck to it. He was like, I didn't do this. I didn't do this. And he was very forthcoming and honest when this first happened. He was like, oh, hey, by the way, I happened to be there that day. So he was pretty honest guy. But because they had no other leads, no one else they could put it on. Yeah, they are a real cult. But they are not really that known for making those kind of sacrifices. The group overall does not make those kind of sacrifices. Right. They did. They made him out. They really did. And I never thought, I was probably one of the only people on the planet who never really thought that he was the right guy. But they really did put him out there painted him as the guy, the only guy. But I think the pressure was on them to have someone, and they wanted justice for these little girls. And I don't think his voice matches. I mean, they had nothing to go on. I just don't think that he is the guy. So I think that they pulled a confession out of someone that, you know, I don't think they ever had enough to identify anyone either. I think that, you know, it just so happened that it was convenient. It was a matter of convenience. It was, you know, hey, we got nothing else. We've got to solve this. And I feel like, you know, I mean, it's kind of like Michael all over again, you know. Nothing to see here. We've got to have someone take the fall for this. And, you know, no one's going to care about if it's this guy. So, and just the way they just create more victims. You know, they pick people who they think nobody will miss and nobody will care about. And, you know, I think it's really sad. Yeah. Did you guys see on the news? I don't remember which city it was, but somewhere up north, they exonerated 3 people. And it's the first time in history that they have exonerated that many people. So it's pretty, I mean, this is why I'm on the side of, you know, we really do have to get justice, and our justice system really needs to work. And I really feel like, you know, we've got to have the evidence. We've got to have the right person. And I just think in this day and age, we can't keep going with this, you know. I know we want people to pay for the crimes, and we want people to we want that justice. Let me see if I can find it, because 3 people were exonerated. For the first time in history in Philadelphia. So yeah, it's crazy. This is wild.
Philadelphia murder and jailed for decades since will now walk free. 3 men convicted in the 1997 North Philadelphia murder and jailed for decades since will now walk free. Philadelphia's district attorney said today that all 3 men have been exonerated now following a re-examination of the evidence. The DA says that new look revealed a case that was built on a flawed foundation. Action News' John Paul live at the Criminal Justice Center tonight. John, we understand those 3 men just walked out of jail tonight.
Yeah, Brian, 2 of the 3 men walked free in the last 10 minutes. They were being housed up at SCI Phoenix in Skippack. I've been told they were just released, but we are still waiting on that 3rd person. There seems to be maybe a miscommunication going on right now. That's happening in Chester. But right here where I'm standing, the district attorney was here earlier today to talk with the judge. During this case, the judge sided and said, hey, these 3 men should be exonerated because this trial was flawed.
I'm saying they were robbed of a fair trial. and their conviction has no integrity.
After nearly 30 years behind bars, these three men will walk free tonight after their murder convictions were thrown out in court. Today, District Attorney Larry Krasner spoke outside the Criminal Justice Center after a judge granted the exonerations of Jermell Schuler, Rashid Smith, and Mark Brittingham.
You cannot keep people in jail forever who were robbed of a fair trial.
They were convicted in the murder of 73-year-old Essie Mae Thomas on North Judson Street in North Philadelphia in 1997. She was found beaten and stabbed to death in her apartment. The three men were sentenced to life in prison. But the case hinged on two things: the time of death and an eyewitness, and Krasner says both were flawed.
The only witness in the case who actually put these men close to this woman who was murdered is a known liar.
The DA's office says the time of death was incorrect. They secured experts who say it was at least a day later than what the medical examiner had testified.
That placed the time of death at 24 hours after the trial medical examiner said that she died, and that the sole witness saw these defendants on the victim's porch.
This was a grave injustice. It's a case that was flawed from the start, and it just completely collapsed once we determined that the medical examiner's time of death testimony wasn't reliable.
While these three men will be released, there is no plan to retry them in this case because the DA says there's no evidence. So the murder case of Essie Mae Thomas remains open.
We cannot forget that there's also a family out there now that have had this traumatic event reopened.
I mean,
Brian, a few more developments here in just the last
30
few minutes.
years.
That the third man, Mark Brittingham, will not be released until tomorrow. The other two, Jermell Schuler and Rashid Smith, they were released in the last 10 minutes from SCI Phoenix. But for some reason at SCI Chester, there was a miscommunication, maybe some paperwork mishap. So that will take place tomorrow. Now, one other thing to note is that because of Pennsylvania law, they are not due any compensation
So
for the years they spent.
this is something that we see all too often is time of death, y'all. Time of death
All those years
is
in
a
prison.
huge disconnect in a lot of these trials where people get convicted wrongfully. It's just shocking to me. And then also, I believe in Tennessee, there was his execution was stopped. He was actually, because the lethal injection did not work. So they stopped his execution. It smell like molasses. Like molasses. I'm trying to think of what trial is coming up on the 1st. There's a trial coming up on the 1st. It is darn it. What is it? Oh my gosh. I don't know where Gwen gets her news. Trying to think of who. What trial starts on? Oh, Tony Carruthers. He's the execution that was supposed to happen last Thursday, and something went wrong with the lethal injection, and it got put on pause. How wild is that? And I mean, the families were there and everything to witness it. And something did not go right during the execution, and they paused it. He represented himself during his trial. He kidnapped and buried alive the people. I don't know. I don't know what happened. That is wild. That is wild. Could you imagine showing up to like the execution of someone that you have been waiting to be executed because for justice, and you show up and they're like, you're going to watch it. Like, can you imagine going to watch an execution? Oh, that would just be weird. That would just be weird. Okay, so I'm going to put on Carly's since we didn't get to hear the disaster of her appeal argument, I'm going to put that on during this lunch break. Because I've got to go kill some wasp nest. I just had it. By the way, the attorney that argued for her did a terrible job. I don't know what he thought he was going to accomplish out of this. I know, right? Oh, yeah. I remember that. Yeah. I mean, I've seen it done in the movies, but yeah, I couldn't imagine, but I couldn't imagine like going to one, right? And then it not going well. Like, oh my God, in the movie The Green Mile, that was like, oh my gosh. But like, I couldn't imagine going to one and it just like not like, and like, oopsies. Sorry. You guys are going to have to come back another day. Like, what? What the? I'm like, no. Okay, so this is the appeal for Carly Gregg to get at least a new sentencing, I'm guessing. I'm not really sure. So let's hear what they have to say. It did not go well. I was watching it in closed caption and it was a disaster.
My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the state of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the state of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The
Yes.
sentencing order in this case says.
Dang, you already stopped him.
Which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute in subsection 2 of the sentencing statute for first degree murder gives two options. The jury can do life, can give life imprisonment. And if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point. And if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, By giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here. And I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences, life in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years. And this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument. But the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument. But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments. But assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smiley. She was listed as a potential. She was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year. And again, I'm paraphrasing, but you may see her at the supermarket or you may see her at church. You may run into her at any place outside in public. And again, we would argue, and we argued in our brief, that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue and has argued in their brief that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief. We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they begin their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too. If Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smiley or the trauma suffered by Heath Smiley. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated. And in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court in that case vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, "We recognize that there are cases even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed." So we would submit to Your Honors that this court has the power to impose that duty on the trial court, just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now that posture shaped the atmosphere of the litigation from the very beginning. Now you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances. And that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing, in those cases and the text of that rule, still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean,
and I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion written motion before trial or during trial and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because number one, it chilled the litigants. They I hate to say afraid perhaps, but and going back to Smith versus State,
I'm
I
not
would
sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluations, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on, because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me as a defense attorney to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Monotony standard. So they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power. The court does not have the power to order Carly to undergo psychiatric evaluations at the behest of the state. The court.
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right. Does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
The
evaluation?
only reason she declined to render an opinion was because there were some issues with marijuana or some other.
Whatever the reasons were,
Right.
does that affect your argument that it was incorrect for the trial judge to
It
order?
absolutely does not affect my argument. That was premature and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents it wouldn't have otherwise yet disclosed.
Among other things, yes, Your Honor.
But those documents would have been disclosed because the defense did defend.
Yes, Your Honor. If to do the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert, who would have reviewed all those records, and interviewed Carly, and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you.
Okay. Ms. Hartman, the court will hear from you at this time. Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to. So and the sentencing statute in this case allows for 2 sentences: life in prison if that's set by the jury, and a term of years. All right, so the sentencing statute, the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I mean, I get why you say the effect of her sentence is life without possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life in prison.
Yes, Your Honor, it
And you will
does.
agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't know any reason that they would, but if they did, and they were to remove the language that says you're no longer eligible for the language that says you're not eligible for parole if you're convicted of first-degree murder. That's what relegates this effectively to a life sentence we've held. Then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those two statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have?
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole. In Parker, we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller, under Miller, there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, I mean, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, what, a life sentence with the possibility of parole, but that's not what the statute provides. And the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means under the statute life with the possibility of parole. So
I would disagree with that reading of the statute, because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
okay, and I might disagree with that because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past has reformed the parole procedures and the parole. What if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? We have to go back and resentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think Johnson, this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was
The
resentenced.
sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was resentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language life imprisonment under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the senator, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Greg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Greg to life imprisonment. And that, in effect, was the Miller hearing. Just because Greg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing. And the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Greg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Greg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Greg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Greg shot her mom 3 times, point blank range in the face. So obviously that the circumstances of the homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Greg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Yes, sir.
That doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Greg to. And we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Greg's trial, I'll move on to the couple issues that
So
opposing
it's
counsel
just
raised regarding the guilt phase.
It just means no parole. Regardless.
First, in regard to Greg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases.
Just get no parole.
But it's critical in this case that Greg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the quote prospective denial of motions for continuance. Turning to the Monotone issue, really Greg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court. And we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Greg for both confidence to stand trial and monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding in doing a monotone evaluation based on the fact that Greg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Greg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Greg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct monotone evaluations that Greg said, no, we object to that. We don't want her evaluated. We're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under monotone, Greg did not object. And in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being monotone evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Greg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Murphy.
How much time do I have? May it please the court. I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole, irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but it was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing. And I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever is deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of section 4773 to sentence Johnson, who was 17 when he committed first-degree murder, to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, section 97.321(2)(b) allowed Carly Gregg's jury to sentence her to life without parole, consistent with section 47.73(d), which is a parole statute, but only after it considered the Miller factors. However, The trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97-321 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counsel. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have been she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection. And I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involve artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that
Going
book.
over in time again?
She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited in by Justice King and Jordan v. State, by the Jersey Court and State v. Skinner, by the Ninth Circuit and United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
He's still talking. Sorry, y'all. I forgot about our other trial. Oh.
We were just showing two envelopes labeled.
No, I
English
did not
body-worn
see that.
camera. We just spent a lot of time yesterday talking about what needed to be redacted out of English's body-worn camera. We did that and played it today.
Is it good?
I'm unclear what they want to introduce as far as English body cam because we just played it today. And all I've seen is an envelope labeled English body camera. The other one is Carter. I believe they have Carter on their witness list. There has been no stipulation as far as hearsay exception. The statute is 19-5-520.
Oh, gosh, sorry, also forgot.
Again, that is why we spend a lot of time muting several parts of our body-worn camera belonging to English because there was a general objection to things that were spoken about in those body cameras. And what they're seeking to do is introduce through English, the next witness who's on the stand now, something he didn't hear, something he wasn't privy to. It was a statement made to another officer.
Well, you don't have Netflix, Gwen?
Then I got a problem.
What
because
planet are you on?
What is the exception they're offering? It couldn't be a party opponent.
Oh my
Trying
gosh.
to offer something Mr. Chow said to another officer who's not in the courtroom today. I don't know what the exception is. They certainly can call him to the stand and talk about any statements he made to law enforcement that night.
You're missing so much.
No, they can certainly call Chick Chow to the stand to say anything that he remembers saying to law enforcement at the time. So just to be clear, I know this is confusing. Your Honor.
Oh, really? Oh.
They are seeking to introduce a body-worn camera that contains a statement made by Chick Chow to an officer. So they're seeking to do it through English. He wasn't there to hear any of these statements. I don't understand how he can testify.
I watch it for the K dramas. Are you kidding me? I should have
All you
an
gotta do is
YouTube
call
channel where I just
to authenticate the video, to talk
react to
about
K dramas
what he's saying, what
and
he's saying,
Keanu.
but then
K
they still
dramas
have
and Keanu.
hearsay. Perfect.
I don't know why I don't
They
do
can
that.
certainly call him to the stand, and if he says something different, then we can impeach him with a prior statement. I don't know if I know it's a confusing.
I'd probably actually make money
They're
if I
trying
did
to
that.
introduce something that this officer wouldn't be privy to. Something that's picked up by a completely different officer's camera.
Because I'm going to have to get a real job.
Your Honor.
I'm not going to be able to do
the
this.
The facts of what he did not hear are just as proper to ask this witness about in the context of what he's now saying.
Where did this lawyer come from? Holy moly, look how many lawyers this guy has.
Mr. Carmack-Belton pointed a gun at Andy Chow. That was very much communicated.
Oh my
to
gosh, he
officers
has
on scene
an
that
attorney
night.
that's every age.
And the state is
So
really
the English's body worn camera is already an exhibit.
English is body worn camera. So what we're really talking about is Carter's body worn camera. When English is asking Mr. Chow, what happened, and he starts getting into
Like
the
every
substance
lawyer
of
in
it,
South Carolina.
and the very line that he starts referencing the gun that Mr. Carmack-Belton had, he walks away to go talk to Andy Chow.
Right?
I think everybody saw
Crazy.
Right, and so the rest of the statements that Mr. Chow is making
All for
about
one person.
the gun to
He is
Deputy
really
Carter,
trying to get out of this.
There is no objection the state can have at this point in time, regardless of whether this witness has knowledge. We have stipulated to the foundation, we have stipulated to the hearsay exception.
I think it's still got to properly come in through the
They
appropriate.
do. One of his attorneys is
That would be
sitting
for
by
the
the court
purpose of
reporter.
establishing a foundation, if I'm not mistaken. And we've already stipulated that.
And I don't see how English establishes an appropriate foundation for Carter's body cam.
Well, we've stipulated that it need not be authenticated. No additional foundation needs to be laid for any of the 911.
I mean,
any of
this is
body
the
cams,
first
any of the
witness.
statements.
I don't think anybody has done that.
And I'm,
I did the business record affidavit motion, can I?
Yes, ma'am.
Okay, so in the notice that we sent, and even on the record, we said that pursuant to
Look at
section
this.
19.5.520. So I'm not sure which 803 thing keeps talking about. That's not the grounds that we got those business record affidavits.
9
That's under
attorneys
statute.
for the defense.
And what we talked about on Friday was that the business record affidavit, the purpose for the body worn cameras is that the
7 for the
themselves
prosecution.
are authentic, meaning we didn't have to call English to say, yes, this is my body camera. But their main objection, I believe Mr. McCullough was the one who said it, was that, yes, we will say that these videos are authentic, but we may have objections to the hearsay that are in the business record, which is typical with any business record. It was a medical record, and there was hearsay in it, you couldn't just put the medical records in. And that was the whole thing yesterday with English's body worn camera and the statements of Lori and Kennedy and the other witnesses. They want all that muted because it was hearsay. It's the same thing in Carter's.
This is insanity.
And that's why the video surveillance is hearsay in those body cameras. And English didn't even hear the conversation. And like you said, there's no hearsay exception. We did not stipulate to the hearsay in the videos.
Oh, good Lord. It's not for the truth of the matter.
we're pretty flatly misrepresenting the record. Our entirety of our objection was 1 under 403, which the court recalls, and 2 under the confrontation clause, which is unique to a defendant. We have stipulated that the business record notice we got that contains reference to the statute that the state just cited is the notice of intent to offer business records, which is the hearsay exception. We agreed that all of this meets the first line of hearsay exception. And now the state is trying to dig itself out of this stipulation when we're offering this to state.
Look, she already standing up.
Anyway.
Like, I got something to say.
The state doesn't want, us to be able to correct the impression that it just made.
So they're trying to allow video in. Notice in the earlier, before the video that was being played, a lot of it was being muted out. Now the defense wants to play
Who said
video.
what about Mr. Carmack-Belton pointing a gun at Andy Chow that night? And we haven't even gotten to the rule of completeness.
We ain't gotten to nothing.
If that's needs to be reserved for our case, then so be it. But in fairness, there's no reason under the agreements that we have already made
I mean,
that this can't be offered, time now.
The agreements are, it is what it purports to be, not that it comes in through any witness. We just not need to put it in. We just throw everything to the jury. So we are.
Be or not to be.
Here to see.
That is the
That's what
question.
you're asking, essentially.
If the parties were to agree to all the, predicate legal issues, then we theoretically could do that. But I just don't understand what the state's issue is with putting the complete statement of the defendant.
Appropriate witness.
Understood.
Yeah, if you need to cross-examine him off of his body worn can, you can, but not off the body.
Understood, Your Honor.
Anything else? All right, then, jury, please, Mr. Cole.
Holy moly bajoli at the amount of lawyers, paralegals, receptionists, doormen, pen holders. What the heck? What is this? Is this South Carolina Law School? What is happening? That looks like Ron White. I swear. Oh, I mean, this is fun. This is fun. This is hilarious. I just wish they'd get on with the damn questions. My word. Oh, it's like watching paint dry. I mean, at least in Josie's trial, those attorneys were entertaining, even though they were complete jackwagons. At least they, had some oomph. These attorneys, for the love of Pete. Oh my word, girl, look at them heels. You got, girl, you must not be making no money as a lawyer. Look at them calves, girl. Oh my, it's because you wear heels like that. Oh my goodness gracious. Look at her, she ain't even tall. Imagine how short she is without those heels on. She's just a little bitty thing.
All right, ready for cross-examination?
Girl, now how you rocking them heels? Whew. You're gonna walk like a pro in them things too. Oh Lord, oh Lord. Great grandpa's questioning. Oh Lord. Civil War grandpa questioning him. Please don't.
All right, Mr. English, I remind you, you're still under oath. Swear.
Thank you. Hey, Mr. English, let me ask you, when you were standing there and you had been talking to Mr. Chow, at some point when you asked the question, you walked away, somebody called you and you walked away from Mr. Chow. Do you recall that?
Yes, sir.
Okay, and that was in the middle of a conversation about whether or not somebody saw the weapon or not,
Yes, sir.
correct?
Yes, sir.
And Mr. Carter was standing right near you, was he not?
If I can remember so.
Pardon?
If I can remember correctly.
And did you happen to hear the conversation between Mr. Carter and Mr. Chow?
No, sir.
Did you happen to review it later?
No, I never watched his body count.
Are you aware?
What the?
But you do agree that at the time you were asking that question, you got interrupted and walked away, and Mr. Chow was standing there. You didn't follow up, correct?
Correct.
All right. Got a few questions I'd like to ask you. When you arrived on the scene, Mr. Chow was still there, correct?
Correct.
And his son was still there, is that correct?
I don't recall it.
You don't remember whether, okay, all right. And did you observe what Mr. Chow was doing when you arrived?
I know when I arrived,
Fix it.
he told me that there was a firearm on the ground.
Did you see him giving any kind of life-saving measures to Mr. Carmack-Belton?
No.
You did not see him.
I observed the other female
Okay.
giving chest
But
compressions.
he was standing there
Close.
at the time you saw him?
Yes, sir.
Okay. And he stayed there and he spoke with you when you asked him some questions, correct?
Briefly, yes, sir.
Yeah. And we've already established that at some point you didn't follow up with the question, but Mr. Carter was standing right there, correct?
Correct.
All right. Now, you went ahead and you found the book bag.
I was about to make a comment and be like, speak up, son, I can't hear you.
The drainage ditch, yes, sir.
And you picked up the book bag, and at the point that you picked it up, you did not realize it had anything to do with the case. Is that correct?
I was unsure.
Pardon?
I was unsure if it had anything to do with it. Yes, sir.
But you did take it into your possession.
Correct.
And did you open the bag?
I looked inside briefly.
All right. And do you recall whether or not what was in the bag? Some papers?
Miscellaneous
you didn't see any
documents.
money in the bag, did you?
Not that I can recall. No, miscellaneous items, a few documents. That's it.
Okay. And what did you do with the bag at that point?
Put it back in my trunk.
And that's where you put the other items as well.
Correct.
When you found the Taurus 9mm semi-automatic weapon in the area, you went ahead and you picked that up. Is that correct?
Correct.
And you took it over to your
And miscellaneous items.
Correct. It's on the video.
Yes, sir.
And you went ahead and cleared what we call clear the gun. Did you not?
Yes, sir, I did.
And when you cleared the gun, you realized the gun was loaded, correct? Did you pull the magazine out as well?
I did.
And the magazine had a full clip, correct?
It had rounds in the
It
magazine.
had
yes.
rounds in the
And
magazine.
there was a,
It's not a
when
clip.
you pull back the slide on the Taurus 9, there was a bullet in the chamber. Is that
There was a
correct?
round in the chamber, correct?
Yes,
sir.
a round.
You-
Oh my God.
You removed that bullet from the chamber, and then you safely put it in your vehicle, correct?
Yes, sir.
So at that point, the pistol was ready to fire, correct? If there was one in the chamber?
Yes.
Pardon?
Yes.
Now, also, with respect to this, I guess you call it a laser, a light, this was something that you put on a pistol, correct?
The tack light was an attachment.
In this particular situation, this is a combination of the laser and a light, correct?
Yes.
That you put on the pistol.
That you can
And it
attach
has
to
a
it.
certain groove on top of the pistol and the bottom to go ahead and attach it to it.
Yes.
Okay, and I believe you said it was common, but I mean, law enforcement doesn't carry those, as part of your normal duty, do you?
Law enforcement carried tack lights. That is correct.
They carry a tack light?
Yes, sir.
With a laser?
No, with the laser.
Oh,
The
well, that's what I'm
light.
asking. What's the
Yes, they're
point of
talking about
having
the
a
gun.
laser on a tack
He
light?
had a Taurus
I
9mm
don't know. I'm not sure.
Accuracy?
with a tack
It could
light
be, sure.
and a
You put the
laser.
laser on a target and it's dead center, correct? You can
By the way,
hit
a
that
Taurus
target
is the
because the
cheapest
laser hits that target,
of
does it not?
all guns.
I'm not an armorer, so I'm not sure.
So cheap.
But you agree that the laser itself is not standard equipment, it's not something that's common, correct?
Yes.
Tack light is,
Yes.
but not something with a laser.
Yes, sir.
You wouldn't go that far to say that's a common.
I would not waste my money
common
on
instrument
putting a laser on a
a,
Taurus.
Pistol, correct?
That's not common. No.
All right, and this was a semi-automatic with a hollow points or full jacket bullets.
I can't remember.
So you cleared it, you put it in your vehicle, And then you
I wouldn't buy a
found
Taurus.
the laser tack light, correct?
Correct.
And you took that to your vehicle and you stored it in your vehicle as well, correct?
No, I didn't pick up.
What did you do with that?
Stayed there until crime scene came. It was marked.
Okay, so, but it was taken into evidence.
It was, yes, I
You
guess you could say
didn't, but
that.
somebody else took it.
Yes.
And as far as you were concerned, I believe you put it in your report that that tack light laser went with the 9mm Taurus pistol.
It could have been
Correct?
attached to it, yes.
That was your conclusion.
Yes.
In fact, you wrote a report about that,
That is
correct?
correct.
Okay. So again, let me just ask one, you cannot explain to the jury why someone would have a laser on a pistol or what the purpose of it?
Dude. Yeah.
No, just because I'm not a armor, but I noticed it had a flashlight on it.
Pardon?
I realized it had a flashlight on it, which is
A flashlight, yeah,
tactical
we're talking
attachment.
about a laser with a red dot.
Yes,
You-
I'm
you
not.
Put
tell
it
the
on
jury,
there so you can.
You're law enforcement, how long have you been in law enforcement?
4 years.
You cannot tell the jury why you would have a red dot.
You
laser
put a
on
red
it.
dot
You can use it
on
for accuracy.
accuracy.
Law enforcement doesn't carry it unless it's on a rifle. But as far as anything else, I'm not too sure. It's not really common, but the flashlight portion of it is very common. People use it when they want to see at nighttime.
Because it makes it
into
look
a
cool.
Room that's dimly lit. That's what you use the flashlight portion for. That's
Sure.
correct.
But when you made a comment on direct examination that it was common, you were referring to the light. You were not referring to the laser with the red dot, correct?
Correct. Yes, the
That was
flashlight is
not-
common.
Correct?
Sure.
All right, so we know Mr. Carter was standing there. Let me, you also, so you found the Taurus, you found the light, laser light, you found the bag. Did you, you knew that the folks had come down from the gas station down to that area, correct?
Can you
On
ask the
the
question
street?
again?
The people had come from the gas station down to the area where Mr. Carmack-Belton was, correct? From the gas station down.
The
to
bystanders?
street. Pardon?
Bystanders?
I'm sorry?
Who were?
No.
What people?
The people that were involved, Mr. Chow, his son.
Yes, they
Carmack-Belton.
came from the gas station to the incident location. Yes, sir.
And you had found the bag on the side off the road, correct?
In the drainage ditch. Yes,
Yeah.
sir.
Did you conduct any search on either side of the road for any other item that you were aware of? Or did you?
Briefly, just in between making contact with witnesses and EMS personnel and fire personnel and Mr.
Were there
Carter.
woods and there are bushes on both sides of the road, correct?
Sure.
All right. And are you aware of whether or not a search was made of both sides of the road to see if there were any objects that seemed out of place?
Not that I can recall.
There were some people that came to the scene that were in one way or another were witnesses, supposedly witnesses, correct?
Correct.
And did you interview any of them to find out exactly where they were standing to determine whether or not they could observe what they were saying?
I talked to them briefly, but investigations were there. Investigators.
And that's what I'm trying to decide who's doing what, but that's not something you do.
I mean, I can if I'm the only one on scene, but
Pardon?
I can if I'm the only one on scene.
I know.
But due to having other personnel there, I
You're
allowed
right,
them
but
to
that's
do
what I'm
that.
saying. There were other people there. You did not do that.
Correct.
Let me ask you, this young man, Mr. Carmack-Belton, was 14 years of age. Is it legal for him to have a pistol?
It's not legal for him, for
Pardon?
any juvenile, no.
Was it legal for him to enter a store that's marked with no weapons and may enter?
I don't know if it was posted.
Pardon?
I don't know if it was posted, but no, it's not
If it
legal.
was.
No, it's not legal.
It's not legal, correct? So it's a criminal offense.
Correct.
And it would be a criminal offense for him to possess that particular weapon as well.
It'd be a
correct?
weapons law violation, correct?
But turning on the other side, you were able to determine that Mr. Chow had a concealed weapon permit, correct?
When he showed me, that is correct.
And that he had it, when you saw him, told him he had it in his holster, correct? Correct. Okay. So we talked about the collection of evidence. And did you collect any other items of evidence at that point?
No, besides what we marked with a AA marker and AB marker, the backpack and the firearm.
And you marked those with those markers, and I think one of the
Crime scene
markers
did.
was a notebook that you put down.
Yes,
just
sir.
to make sure you knew exactly where it was.
Yes, sir.
Is that right?
Yes, sir.
I'm just going to go through, I'm just going to hit some points that I like to make, and just permit me one time to read it a little bit. All right, I'm not going to ask you some questions I've already asked you, but the backpack, do you remember anything that was in the backpack? Did you make an inventory of anything in the backpack?
No, like I said, miscellaneous documents, like two brushes.
Okay. But you didn't find any money in the backpack?
Not that I can recall, no.
I'm not going to ask you any questions that I've already asked you. I'm going to ask you questions I've already asked you. The entire point of a laser sight on your handgun is for accuracy
Were you the one
and a
that
target.
got the 2 cell phones and the shoes, or was that something you
And it
picked up
looks
or
cool.
somebody else?
If I'm not mistaken, maybe crime scene. I'm not sure though.
Okay, that's fine.
Flashlight on a handgun is for obvious reasons.
You would agree that you did not you didn't conduct a full interview yet like you would want to of Mr. Chow, correct? There was just a couple of moments that you spoke to him, and you had to go off somewhere else.
I just asked him what happened.
Pardon?
I just asked him
Right, but
kind
you
of what
agree
took
it
place.
was a brief conversation.
Brief conversation,
And
correct.
it wasn't really with no follow-up questions, correct?
Not from me, no.
Excuse me, 1 minute.
And attorneys use words like clip or a gun just to for shock factor for the jury. You don't call a magazine a clip. That's not what it's called. They use that in movies. They use it in trials and stuff like that, just for shock factor value. Politicians use it. People use that just to make it sound more impressive. Just like when I say this all the time, there is no such thing as an assault rifle. A rifle cannot assault you. The politicians use it, lawyers use it. There's no such thing as an assault rifle. An AR is the word AR. The acronym AR stands for Armalite rifle. That's the company that makes it. It does not stand for assault rifle. So I just want to clear that up for everyone, because it really pisses me off when people say assault rifle. There's no such thing as an assault rifle.
Help in accuracy. Is that what you said?
It could help with accuracy. You see it more on a rifle than you do a pistol.
Did you have any reason to believe Cyrus used the laser inside of the shell station?
No.
Did you have any reason to believe he brandished the gun inside the shell station?
No.
Did you have any reason to believe?
That's not proper, is it, right? I didn't answer anything about that.
He was asking about the laser and what they're used for and aiming weapons, right? Wasn't that the question you were asked earlier? Okay.
Yes, sir.
Did you have any reason to believe, while you're on scene, that he brandished the weapon or used the laser in the parking lot of the Shell gas station?
No, sir. I have no reason to believe that.
Okay. Is any of that called on that you're aware of?
That he brandished a weapon?
Yeah, I object because that's not redirect.
or flashed a laser at any point?
I know that answer.
I'm gonna sustain that.
All right. You were asked about 14-year-olds can't legally carry guns, and you said, that's correct, I cannot.
Yeah, that's correct. I legally cannot.
And then criminal offense.
It is.
Concealed weapons permit users have to follow the laws too, do they not?
If I'm not mistaken, yes, sir.
Okay. I mean, laws still apply to concealed weapons.
That is correct.
You were asked about money. Did you have reason to believe, or to your knowledge, did people move some evidence around before you guys got there?
Yes.
Okay. I think in your body camera, Mr. Chow even says he moved
The firearm, correct.
firearm. Okay. How did the shoe, Cyrus Carmack-Belton's shoe, and how did those 2 cell phones get inside the convenience store?
Someone had to move them.
Somebody moved them there?
Oh, yes.
Okay. So you didn't find anybody, but you were told by the Childs that they had moved evidence around.
Yes.
Okay. That's all I have.
All right, you can step down, Deputy. Thank you.
Your Honor. Ask what is not to be excused.
Mr. Just approach.
Yes, sir.
Hang tight.
All 40 attorneys, please come to the bench. Well, whatever, they're going to make an example out of this convenience store guy. They're not, I don't understand how this child had this weapon. Again, I'm just going to say, don't buy a Taurus. They're cheap. If you're going to buy a gun, go with a Glock. It's a never fail. Shoots every time. Swiss made. Get you out of a pickle. It's not fancy, but it's a good, reliable weapon. You can dress it up, dress it down. My favorite is a Walther PPK. That's the James Bond gun, by the way. Well, not the PPK, but the Walther. That's James Bond. The most beautiful one is a Kimber. But the Kimbers are very, very expensive, and they actually are not that fun to shoot. They're pretty to look at, but they're not that fun to shoot. And when I see these kids out shooting these AKs are rough. I don't know how they did use those in Vietnam. Holy moly. Those things are really, really tough on you. Oh, I don't know what the heck is happening. I don't know how many people on here are gun people, but I went out during the lunch break and killed and removed the wasp nest, and they keep coming back looking for their home, and I keep telling them that their home is gone. I destroyed it. And they keep coming back for it. It's really annoying because I want them to go away. Because at some point, I would like to have my hammock out there and have a nice place to relax without the harassment of these wasps and bees. We have, I was telling Gwen earlier, we have rabbit. Neo has turned into quite the rabbit chaser. He might lose some weight chasing all these rabbits. We also have bobcats, apparently. That's a thing out here. What's my other favorite? An AR, the Armalite rifle. I love the AR.
It was like one of the last questions. It would have been towards the end of Deputy English's directive.
I also enjoy the 12 gauge pump action. I have a traumatizing story about rabbit. We lived in Germany growing up. So my Herr Butze raised rabbits growing up. I used to love that. I love bunnies. And my mom, because she's an evil person, made me lunch one day, and I thought it was schnitzel. And she was like, "Oh, how do you like that schnitzel?" And I was like, "Oh, it's really good." And she was like, "Oh, it's one of Herr Butze's rabbits." Yeah. Needless to say, I mean, and these were rabbits that I helped raise as a small child. So my mom was mean. Oh yeah. Yeah. So my mom made me eat one of Herr Butze's rabbit, and then she cooked it and didn't tell me till after I ate the rabbit. She did the same thing to me with one of my cows. I had a cow named Ferdinand that I raised from a calf. And my granddad, he raised cattle. And then, obviously what you do with cattle, duh. She did the same thing to my Ferdinand. But you don't name your pets, right? You don't name your food. I totally did. My mom was terrible. My mama was terrible. Yeah, they killed Ferdinand, and and we had burgers one night for dinner, for supper. Yep. And then my mama was like, "How's the burgers?" And we were like, "Oh, they're so good." Yep. She's like, "Well, that's Ferdinand." Then I bottle fed from a calf. Yep.
Mr. Scott asked of Deputy Investigator. Mr. English, when he was on the stand on that one, about who did he tell, was anyone told?
I know, right? Oh my gosh, I hate when they do that. Figure it out. Yeah, I always joke with Neo because we went to Asian market yesterday, and we've been taking Neo everywhere with us because we moved, so he's like freaking out. So he's not very happy about us moving and all that stuff. But we had to go to Asian market yesterday because I had to go get my sweet potatoes and all this stuff, my Korean food. And I was like, "Boo Boo, you can't go with us because I can't take outside food into the store." Oh, Mike was dying laughing.
And then what did Mr. Rick Chow do as Cyrus was running away, in his own words? Told him to drop the weapon and proceeded to shoot one shot or fire one round. that what you're supposed to say?
No, ma'am.
It was right before.
It was right, okay, yeah.
Okay, we're getting there.
Yeah.
The testimony under oath is nobody said, told you that night that Cyrus pointed a gun that night. Answer was no, so no one told him that.
Question was nobody told you.
Okay, is there anything further after that? I just want to make sure it's clear.
And in your body cam, when you talk to Rick Chow, what does he say? Did you say you ever saw a gun? That's where I just read.
Ma'am?
That's where I just read all that
Okay.
stuff before.
Okay, I want to do that, and I just want to be clear and cover myself for the record. I understand your question, Your Honor. Understanding, and we want to properly put this in, we believe the connotation left with the jury. And if you cite rules specifically 106, when a writing or recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part of any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. I don't know if we take, and I've shown these, Your Honor, and I've shown these to the state. These are part of the transcripts of the video that you have already seen. The first one at the top of it says English #1. That is what you watched and what the jury watched on the video screen. If you notice, it is highlighted yellow. At the last yellow line, it shows when this officer walked away. If you then go to the second page, which says Carter #1, it shows where the question that was being asked of Mr. Chow, in which he was continuously answering the question that started from Mr. English and allowed him to finish the question that he was asking. So I'm showing you this is a continuous, contemporaneous statement, in which it goes against the solicitors making the suggestion that Mr. Chow never said on the side. And of course, we said it never said on the side that a gun was pointed at Andy and that with his son. And if we go to number 3 of that, that is when he specifically states that the gun had been pointed at his son. We are just offering that, Your Honor, as and the reason I've given you those 3 pages is to show that this is not a portion of a statement. It is one continuous matter. It is not, and I know it seems like it's 2 separate body cams, but it's one statement is why this is important. So I know it makes it seem as though Mr. English is doing one interview and Mr. Carter is doing one. It is one interview and Mr. Chow is giving one consistent statement. And then to stop it where they have stopped it and say, well, if that's all we want to utilize, and then to be able to ask this.
Oh my gosh, Mark, no.
You about pointing his son, or firearm being pointed at his son. We don't know what they're going to call Carter. And of course,
Yeah, my grandparents had cows and they raised cotton.
To possibly impeach him, and I understand now that I've heard the question, of course, they're not allowed to
They
do
did
that.
all the things.
Specifically under Rule 106, and if you read the case law that discusses under.
Why did you all think you were going to lose your arm?
This situation in which it's a continuous state. So that would just be our position that we should have the right at this point in time, and not to wait until our own case or wait until the next officer, to be able to put in the entirety of what happened on the scene at that point in time. So we don't leave the jury with the impression, the incorrect impression, that this was not said. Because we know it actually was said at that point in time. I understand the court saying, well, you guys can go ahead and call him.
Oh my word, this case is, wow.
Because it's fresh in the jury's mind. Making us wait a week and a half or however long this case would take is why the rule is actually clear. Thank you, Your Honor. Thank you. And I apologize for making the jury go out, but I think I need it. And I can happily, if the court wants, I think we already put the body on camera. I know I gave you the clips, so you can actually put the word in direction of Grady's court.
All right, well, I think I've already ruled, allow you to make correct.
Thank you, sir.
All right, Mr. Toby.
Oh my gosh.
You still want, Mr.
That's
English
funny.
still under subpoena?
We We do, Your Honor, but I do not mind
She
leaving.
was like, I'm going for a run.
I'm sitting around. It's okay, let me contact you, we do your retestify. He said that won't work. Okay, then he's under subpoena.
You're still subject to the subpoena, but you can leave today.
I think he said yes. Okay, I thought he said that wouldn't work. I was, just let y'all clear it up before. Can I just talk to the witness, Your Honor?
Yes, sir.
This is wild. I feel like they were not prepared. This happened in 2023. This is the same situation as Josie's trial. Like this happened in 2023. Josie's happened in 2023. I feel like they just don't have anything together.
In Washington, D.C. starting tomorrow, and be there until September, and I would not want to do that to anyone who thinks I miss things. And we can figure out a creative way to get the rest of that information in. That's why we had that conversation just now. I understand that. Let this work.
All right, you're released from your subpoena. Thanks for being here, Bill.
And Your Honor, if possible, do things that I just gave you, if we can make this work.
Yep.
Thanks.
12, 13, and 14.
And Your Honor, just for the record, understanding that we will, based on the rulings, have to, if we have no problem with calling Investigator Carter, one, I want to make sure he has not been released from the state subpoena. They don't have to tell me they're planning on calling, to make sure he has not been released from the state subpoena.
We told them we were not going to call. That's what I told them.
Oh my word.
But he has not been released from the state subpoena as announced, and he is still under subject to the subpoena prior to court. So we would just ask the state not release him and not tell him that he may not be required to testify.
I told them I would not be calling. So y'all need to do it.
Yeah, the court in fairness now.
You should have let that sheet go, Mark. You should have been like, go on with your bad self.
My concern, Your Honor, is, and I understand you nefarious purpose, but to put that testimony in and then realize that they were never going to put in the second part and now put that question in front of the jury. This is why the rule of completeness exists and say, and they knew they weren't going to call this witness. That's why. They knew they were going to call this witness. They asked that question specifically. They knew they were never going to put this witness on. And then to say that we don't have a right to put the rest of the statement in unless we do something else and not. I just asked, we have no problem with calling this witness, but it's very wild that the state is saying, well, I told them I wasn't going to call him.
I thought they were doing something then.
Oh my gosh. I thought you were going to do it. No, you were.
No, I have no problem with that. I'm just making sure that they have had contact with him. He is a deputy, law enforcement. Always much easier for the state to have someone show up to the district. That's all I'm asking. They've had contact with him, make sure he's not released for the subpoena, the defense will be calling him, or he can be told that he is a court witness and cannot be released. I'm very concerned now, especially given the impression that they just gave to this jury, that there's a reason that they don't want this witness to show up.
Look at all the defense attorneys.
Yeah. And then this goes back to Mr. Curtis, that there will be question of whether or not, and I know there's confusion now, whether there was a stipulation that all this information would be coming in. And so there is some confusion there. But that being said, we'll happily call him so long they don't release him or we make him a court's witness. And if this is an exercise in trying to get the full and fair information out, to simply say, well, we don't know where this witness is, and then I can't stress enough, putting that information in front of the jury.
Well, that just solidifies you being on this channel, Mark. We all love animals on here.
That was a very
I don't know. I think if you don't love animals, then
anything about pointing a gun. I didn't say who has ever said it. And by the way, here's the thing that everybody needs to know. He never told Carter, he never used the word point with him either, did he?
Then there should be no problem with putting the rest of it in.
Calling him.
That's what I just said.
just want to make sure for the record, I know the jury's not in here, but I mean, these words like nefarious keep getting used, and I've kind of reached my fill.
I have
for
too.
the
You got an ethical issue, go down the street and stop accusing people of ethical problems in this courtroom. I haven't seen one yet. I see two very excellent and capable teams advocating for their positions, but I haven't seen anything unethical, and I'm tired of hearing about it. I understand. I'm getting impatient. We've made one witness, and we keep arguing about how many angels we can put on the head of a needle. I've ruled on the issue. You are all great lawyers. You know how to send a subpoena. If you need Carter, you can send him a subpoena. Yes, sir.
Thank you.
Are we ready for the next witness?
I've been ready.
Get the jury.
This judge said, I'm sick of this shit. I'm telling you. Well, look at that judge. He's cutting his eyes at the defense team. He is like, I don't even know what they're fussing about at this point anymore. This is crazy.
Thank you, Mr. Tobin. Going next witness.
The state calls Justin Martin.
I just want them to get on to the point of where the kid was at as opposed to where Mr. Chow was at. I need to see.
Do you swear or affirm the testimony you give in this case with the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. Please have a seat in the witness stand and state your full name for the record.
I feel like he's going to lose too.
Mr. Martin, where do you work?
The Fifth Circuit Solicitor's Office.
And what is your job there?
I'm a body cam and video camera.
How long have you done that job?
Almost 10 years.
What are some of the duties that you have in your role as a body camera and video analyst?
I help gather and distribute digital evidence for our office to receive from law enforcement and then to distribute to defense attorneys. I assist with technical issues that might occur with that digital evidence, specifically with video, surveillance video, body-worn camera videos that might have compatibility issues, and I help the court in achieving redactions to evidence and creating demonstrative pieces of evidence to be entered into court for court proceedings.
In fact, did you do that in some of the videos in this trial?
That is correct.
So in your role, do solicitors and sometimes I guess defense attorneys come to you and commonly ask you for your help in troubleshooting or accessing evidence?
Yes, that is correct.
Okay. And is it common for solicitors to ask you to put together PowerPoints and other presentations of visual evidence associated with the case?
Yes, ma'am.
And sometimes it's one of the purposes of your PowerPoint presentations to condense hours of video footage into shorter, more easily viewable clips.
Yes, we very commonly receive a large amount of video as part of cases. Some of the video that we might receive may be only a very small portion of what we actually receive would be pertaining to the case.
And in this case, were you asked to create a PowerPoint containing shorter video clips derived from some of the video surveillance from the Shell gas station?
Yes, ma'am.
And what is the entity that digital evidence in cases typically come from?
Our largest law enforcement agency that we prosecute cases for would be Richland County Sheriff's Department.
Okay. And is that the agency investigating this case?
Yes, ma'am.
Okay. And is there some type of database that law enforcement uses to share that evidence with the solicitor's office and you share with the defense attorneys?
That is correct. We, most of our law enforcement agencies utilize evidence.com. It's a cloud-based storage and delivery system that they can upload not only their body worn camera or dash video or interviews up to, but also other elements of items of evidence that might be associated with the case, like surveillance or phone dumps, documents, or whatever other material that might be necessary.
And were the videos that you used to create the video clips in your PowerPoint slides, the store surveillance, came from the store surveillance videos in this case?
Yes, that's correct.
Okay, and regarding the store surveillance in this case, were there about 22 store surveillance videos associated with this case?
Yes, ma'am.
And was the duration of some of that footage on those videos up to about 2 hours long?
Yes, every video file had a different duration. Some of them were very long, some of them were 30 minutes, some of them were over 2 hours.
Do some of the videos have audio?
Yes.
And some of them don't?
That's correct.
And as part of your role as a video analyst, do you commonly come across digital evidence, especially like videos, that require unique and specific players to access it?
Yes, it's not uncommon for surveillance video systems to use proprietary video codecs that are required in which to review those videos after the fact.
Okay, and I guess is the MP4 format the most common way to play a video?
An MP4 is the most common in these days video file type that you would find in everyday life. YouTube is mostly MP4s. There's settings on your phone that can create MP4s. It's ubiquitous. It's widespread. MP4s are a very common video file type.
Were some of the videos in this case saved as a BVR file?
That is correct.
And can the average MP4 video player play a BVR file?
A BVR file is a proprietary video file that needs a specific program to open.
And is it a free program?
No.
Okay, what's it called?
Blue Iris, I believe.
Okay, so you have to purchase that software to play the videos.
There is a free trial, but yes, it is a limited trial. You must purchase that software to have access to those videos long term.
All right, may we approach?
What? Approach for what? Oh my gosh. So this guy's just going to verify that he chopped up the videos, edited the video. Move on to the next.
Okay, so did you convert some of those BVR format videos to MP4?
Yes, I use the Blue Iris software that has a limited term to convert it into an MP4 so that we could utilize it in the courtroom.
Okay.
Get it out. Is that it?
I'm going to show you what's been marked as State's Exhibit number 4. Do you recognize what's on the CD?
Yes.
Did you make that CD?
Yes, ma'am.
Okay. And what is on this?
It is a PowerPoint presentation that has video clips of the videos from the video system within the store. More or less clips that just show the action of what occurred in the store as the victim walks in and as the victim leaves, the actions that occurred within the store there. Clips that were removed from the full files of the videos that were received from Richland County Sheriff's Department.
At this point, the state requests to enter number 4 into evidence.
Well, Your Honor, I think it is admitted, we certainly conceded that surveillance obtained from our business was admissible insofar as with the reservations.
Can you speak up for me?
Yes, I'm sorry, I'm a little hoarse. We earlier agreed, Your Honor, to the admissibility, or at least business record admissibility, subject to any further objection. I am not yet clear what this gentleman means by PowerPoint, whether there is editorializing. He is not an expert, as I understand. He is an investigator who was asked to put video surveillance obtained from our store together. If it is simply video surveillance tagged one after the other in some fashion, I don't know that I have an objection. If it has editorial commentary, whether it's typewritten on the screen or otherwise, just not sure what we got here. That's my problem.
We'd be entering the rule 1006. It's just a large amount of videos condensed in different video clips.
Commentary or anything of that nature?
The only thing that we have is like, slide numbers and like an alphanumerical, just like little thing on the bottom so that we know like what slide is what. These are all from the surveillance. They all come from stage 3. That's already in the evidence.
Stage 3.
One second.
Well, hold on a second. Stage 3 is already in the evidence, it just wasn't published, so it doesn't even need to be on. It's in. Go ahead.
Now, in some instances, are you asked to edit videos?
Yes, ma'am.
And when we say edit, you didn't change or alter any of the people's actions or the contents or anything, any audio of these videos, did you?
No, I typically all I will do is stretch out video to make it so that it's a little easier to see. By that I mean to make the frame or the action on screen take up more space on the display. I might make a clip, and you say edit, like that includes just taking a piece of the video out of the larger video to show a clip of it so that we're not watching a full 2-hour video where there's only maybe 5 seconds of action on that video. That is correct. I'm not changing the scenario or adjusting people's location within the frame, specifically just condensing some of the material that was provided.
Okay, and can you edit a video to slow it down, speed it up, and zoom into certain parts?
That's right, yes. Oftentimes we'll slow down video to allow the action to spread out over more time to give the viewer a little bit more time to see what's going on. The same goes for when you say zoom in, like stretching it out so that if, say, what we're trying to see is just taking up a very small piece of the video up on the top right corner or something like that, we'll just expand that up so that it takes up more space on the display. So what's occurring there in that corner is just a little easier for people to see.
Okay, and can you like amplify audio and volume and stuff like that?
Yes, when I adjust audio, I adjust the gain, which is the baseline level of the audio. So it raises the volume of all of the audio that was captured equally. I don't go in and highlight specific areas of audio to gain, to bring the volume level up by gaining. the entire audio track so that it all lifts up.
And can you also combine, or I guess stitch footage from different camera angles in different videos instead of continuous sequence?
Yeah, so in many cases, we'll have video files that are just a specific camera location, but if there's action occurring where there's 4 or 5 cameras pointing at that action, I can cut between the different camera angles to follow the action as it moves around within a location, within a store, wherever the video is taking place.
And did you do those types of editing in the PowerPoint that you created?
Yes, ma'am.
And so you said your presentation is in a PowerPoint format, so you can actually like play the video on each slide in the PowerPoint?
Yes, each slide is a different clip of video that was lifted from the material provided from the surveillance systems within the Shell store.
And did you add like slide numbers to the top right just to kind of so you can see what slide is what?
Yes, to keep track of.
And did you add, oh, I'm sorry.
No.
Did you add like an alphanumeric to like A3 on the bottom, just so like you'll, just as an organization tool for you?
Yeah, so there's a folder that has the clips labeled, and yes, as an organizational tool, there is also a label on each slide that shows what the file name was of the clip that was pulled.
Okay, and when you're creating PowerPoints for a case, sometimes do the solicitors provide you with like some basic background information on the case, like time certain things happen, or like who certain people in the video are?
Yes.
Okay, and does that help you kind of understand what you're looking for when you're making these videos?
Yes, especially in cases that have a voluminous amount of video, having a time frame of when the action occurs, or an idea of what a suspect or a victim or somebody that is pertinent to the case can be extremely helpful.
And in this case, were you given information that the shooting happened around 8:04 p.m. and the victim entered the store a few minutes before that?
Yes, ma'am.
Okay. And in the videos, when you watched them and reviewed them, did you see timestamps on them?
Yes.
Okay, and where did those timestamps come from?
Typically, there's a lot of surveillance systems will burn into the image of the video time code and a date that is being fed to that file from the recording system of the surveillance video system.
This is the
maybe you'll have a
guy who edited
system in your own home
and
plug in
or
to a
surveillance.
little box, a DVR, just like some cable companies will have, where you can
Attorneys
record
have done more
videos
than
that
Patton.
but it will take the video feed
Like the
from the
Josie
cameras in different
attorney.
locations. It'll bring it into the DVR, and the DVR will place on the image of the video a date and a time based on what that box thinks the date and time is.
Okay, so when you were reviewing these videos, did you notice that different video angles had different timestamps?
Yes, ma'am.
Okay, and
He has like
Is
a
that
band
common?
of attorneys.
Is it uncommon?
State has a band of
In the same location, it's not that common. Typically, business would, or a location would use the same system, and then that system would have the same date and time stamped into all of the videos. But in this case, there seems like there was multiple DVRs or different systems that were imprinting the date and time onto those video files.
Okay, and when you were reviewing these videos, were there some videos that like looked like it jumped into time?
Yes.
Okay, and what could be the reason for that?
So there's multiple reasons. If it's a same camera and you see a jump in time, that typically is because there is a motion sensor activation on that camera. So the camera will only record when it detects motion within a specific zone. Oftentimes those are customizable. If you have a camera that's kind of facing the door of a business, it might make it so that if there's motion near the door, that the camera turns on and starts recording. So if there's no activity in a zone that's being monitored for motion, the camera can disengage and not record video off of it to help save space and to focus on whenever there was activity in that area.
Okay, and kind of going back to the timestamps with the incorrect times, in past cases that you've reviewed videos for, have you looked at other types of evidence in the case, like maybe body worn camera times or maybe times on 911 calls to kind of get an idea of what the correct time is?
Yes, body cams are typically plugged in at the end of the night. They recharge, and if there's a discrepancy with the timing on the device that it imprints on that video, it will adjust its clock so that it is accurate again. The same goes, 911 center has networked in their system, so whenever a 911 call occurs, it is always up to date with the accurate time. So surveillance video is typically more problematic about having an accurate date and time because those systems can lose power, and when they begin to receive power again, it does not always account for the time that has lapsed when it was without power. And if the administrator of that device doesn't go in and reset it every time that occurs, you start seeing discrepancies in the time that is being stamped into the video and what the actual time of that video being recorded actually is.
No further questions.
See, I knew it. That's all they're doing is verifying.
Smart, you speak with great authority. You had formal training in editing.
Yes, sir.
What was that?
I have a 2-year degree from York Technical College in video production.
You make movies?
I have made several local commercials many years ago, and I have been a content creator for the County of Richland for their public information channel and service.
You were asked to take surveillance video. You know how many hours of surveillance video? This was video that came from where? You understand?
As far as within the Shell station, in this case specifically?
Whatever you're about to play for us is comprised of, I understood it to be surveillance camera videos. Is that full extent of it?
Yes, sir.
It's not body camera.
That's correct.
And where is your understanding that surveillance footage came from?
7441 Park Lane Road.
The store, the child's name. And you said that you had the participation of attorneys, some of these attorneys in the editing decisions and the construction of this PowerPoint you called?
Yes, sir.
You said that there were a lack of synchronization in camera footage and so forth.
Yes, there was timestamps that were not consistent with the continuity of what was happening inside of the video.
So you made arbitrary decisions in the construction of this presentation because the cameras are not in sync. You made decisions, arbitrary decisions about what fit together.
I think arbitrary would be a strong word. There is continuity that occurs in a space. If somebody walks in and they're wearing a red shirt or a yellow jacket and they come in from a door, even if there is a discrepancy in the time, from another angle, if that same person is coming in wearing the same clothes, even if the time is different, they perform the same actions, and then 30 seconds later, another person comes in. You start to build continuity in between the files because those actions and those people and those specific circumstances don't present again in any other time.
But, your decisions and the advice you got from this prosecution, the prosecutors, you and the prosecutors chose what to emphasize in this PowerPoint, which is a distillation of the whole, correct?
That is correct.
Now, as a Gamecock fan, I guess you would be able to take the films from the game we lose on Saturday night and make the Gamecocks look like winners on Sunday morning?
I don't think that's possible.
I don't have anything else, Your Honor. Clearly not a Gamecock.
No, Your Honor.
All right, you step down. All right, next witness.
State of Lori Carson.
Lord, I think every attorney is going to get their chance. Okay, I think she was one of the witnesses
Do you swear
on the side
the testimony submitted in this
at the
case,
scene.
first of all, please do nothing but truth to help you God? Thank you for accepting the witness stand and state your full name for the record.
Okay, I need somebody to look this up, but I just saw this on Facebook that a dog accidentally shoots shotgun, hitting woman waiting at traffic light. Police say in Nebraska.
Lori Ann Carson.
This happened in Nebraska. Y'all find out if it's true that a dog did it.
Yes. All right. Thank you. I ran out of work at podium. All right. Good afternoon, Ms. Carson.
Okay, Ms. Carson.
The jury, just briefly, just to get acquainted with you, and two things I'll ask real quickly. You got a court reporter who's here. She's going to be taking everything down that you say, so just needs you to speak loudly enough for her to hear you and for each of the members of the jury. And also, I'm glad you did that. If you're not in your head or saying if you could just say yes or no so that court reporter can take it down clearly and nobody will assume what you're saying. Just want to make sure it's all clear.
Yes.
All right, thank you. Where are you from?
Originally Hopkinsville, Kentucky.
And what brought you to South Carolina?
My husband was in the military in Fort Campbell, Kentucky. He got out there and then we moved here to Columbia, South Carolina, where his parents reside.
What branch?
Army.
And are you currently employed?
I am.
Where are you employed?
United States Postal Service.
How long you been there?
25, 26 years.
All right. And do you have other family here in South Carolina?
No, I have just my husband's family and my kids, but my family's in Kentucky.
All right. And so your kids are physically here in South
Yes.
Carolina? Okay. Are they in Columbia?
Yes.
All right. And do you grandmother?
Yes.
How many grands you got? It makes you smile when you talk about that.
Yes. 8.
You got 8?
8.
Good Lord.
All right. So let me ask you this. We're going to focus a little bit more specifically on 2023. So May 2023, you said you have
No,
3 children
Glenn.
who are here?
I do.
All right. Do you mind naming them?
I do mind.
Okay. You do mind? Do you have a daughter?
I do.
All right. And was she living in Columbia?
Now we got to worry about the dogs.
Which side of town was she living in?
Oh, Lord.
Side of town, I don't know if that's, I live on Northeast. I don't know if that's still the Northeast area of Columbia or she lived off of Spring Tree off of.
So off of the Spring Tree Park Lane area?
Yes, yes. I don't know what kind of.
So would that have been the area where the convenience store is located that is owned by the defendant, Rick Chow?
Yes.
Now I'm going to show you just a couple things real quick. First, it states exhibit number 18 and states exhibit number 19.
Okay.
Thank you. So take a look at states 18 and 19. Do either of those photos look familiar to you?
They do.
All right. So if we start with states exhibit number 18, and I think it's up on the board now, so you can handle that too.
Yes.
Thank you, ma'am. So the first one is States 18. Tell me what that is.
A convenience store,
Okay. Which convenience store is that?
Shell station.
All right. And I'm going to show you States number 16.
Oh.
Now that's more of an aerial view. Is that a better
That's
rendition?
correct, yes.
Okay, what is it you're seeing there?
The convenience store, Spring Tree, Park Lane.
All right. On the corners of Spring Tree and Park Lane?
Yes.
And that's the area where your daughter was living back in 2023?
Yes.
All right. Now, if we focus a little bit more specifically on that particular day, can you tell me a little bit about what was going on, what you were doing that day?
We was going, my daughter and grandkids was going to see a movie that they chose. And we just thought Sunday, day before the holiday, we'll just go out and enjoy ourselves.
So you indeed went to see a movie that day?
We did.
All right. And after the movie, what is it that you decided to do?
Take Kennedy back home, but she needed to stop in the store to get something to drink.
Okay. And so the store that we're looking at, is that the store that you stopped at to get something to drink?
Yes,
Had you been in that store before?
twice.
All right. Can you tell me why you've gone into that store?
Yes, my grandkids has been looking for some candy slime liquors. So I was on the hunt trying to find the candy that they wanted. So I stopped in there once and they was like, come back in probably a couple of weeks.
Girl, I'm from Alabama. That has never happened. What? And people had guns in the truck.
I don't believe I purchased it then. They were still stocking up.
But having gone into that store at least 2 times, you were familiar with the layout of the store?
Yes.
A little bit familiar with the different.
Oh, come on.
Yes, I knew where to go to find
Yes, ma'am. And you're a little bit familiar with the decorations in the store?
it. Yes.
All right. I'm going to show you something.
Oh, times have changed. Times have changed.
Same objections as before, but it's been
That is wild.
I'm showing you what's been listed as State's Exhibit 52. Can you tell me if you recognize that picture?
I do.
All right. And in recognizing that picture, you said, were there any things like photos or decorations that stood out to you when you were in that store?
Yeah, a lot of photos.
Okay. And is what you're looking at from States 52 a fair and accurate representation of the photos that you saw when you walked into that store?
Yes.
He must have just had that thing laying in the seat or something. And that dog must
Now,
have just like,
as we focus a little bit more on that particular day, you drove into the gas station.
What kind of dog was it?
Or the Shell station, the convenience store side of this,
Yes.
to pick up maybe some slime liquor or a drink for your daughter?
Candy.
Or some candy. And what happened next?
As I was pulling in into the lot, I noticed.
Nuh-uh. Stop it. A Yorkie?
I noticed Cyrus
I was thinking
Carmack
like a German Shepherd.
taking off running.
Do you know how much
2 other gentlemen
weight?
all in suit.
Look, for a
Look,
shotgun?
you said following suit. Let me ask you this.
Get out of town.
So,
What kind of car were you driving that particular day?
BMW SUV.
Okay, BMW SUV?
Yes.
All right. I'd like to show slide number 20 from State's Exhibit number 4.
Out of town. You need 4
Now, if you're looking
to
at the
6
top
and a
corner
half
of that
pounds
screen,
of weight
can you tell me what you
to
can
pull a
see?
shotgun trigger.
I see my vehicle turning onto Spring Tree.
Oh, look, he ain't running.
So that vehicle right there, and as it's paused, that's your vehicle?
That is
Casually
Tell
walking.
me again what type of vehicle that is?
2017 BMW S5.
He's walking. Oh, his dad was out there too.
What is it about when you pulled into this area that commanded your attention? Let's talk about that a little bit more. You said you saw a young man walk out.
Okay,
of the
that
store.
is nothing like the
Some walking
defense
out
opening
and then
statement.
taking off, running
Okay.
with the two gentlemen running behind him.
Okay. Running behind him.
First of all,
What,
that kid was walking. He
if
was not
anything,
running.
stood out to you as they were running behind this young man?
His shoe flew off when he was.
He was
Now,
not running.
Where would you have been to watch this shoe fly off?
I had pulled onto the lot and I stopped,
Okay.
so I was able to see.
I'm going to show you what's been marked as states exhibits number 21.
And they all three was after him. The son, the daddy, the mama.
States exhibits 20, 21, and 22.
Show it again, because that child was walking. No, this does not match the opening
I'm going to
statement
hand you states
at
20.
all.
Can you tell me what that is a photo of?
Yes, Spring Tree Drive.
Okay.
He acted
I'm gonna show
like,
you states 21.
oh girl, I was like, if it was a York, it takes 4 to 6.5 pounds of pressure to pull a shotgun trigger. I'm like, you
Is that
got
also the corner of that store in the parking lot?
The parking lot, yes,
7441 Parkland Road?
yes.
Store belonging to Rick Chow?
China, you should not have, girl,
Let's start with 20.
tell me lies, tell me sweet little lies.
So can you explain to the jury about where you would have been as you pulled into that store and you saw two adults chasing Cyrus?
I would have been just on the edge. I pulled onto the lot, so I was at the edge,
And I'm gonna,
just off the street.
Oh yeah, if you're not trained to do that,
I'll do,
that you shouldn't do
John
that.
Miller,
That's
witness that now?
Like, if I was not in the store, of course, no one was able to stop a shoplifter. That was my job.
So I have you, if you
So
don't mind.
my days
Ms.
off,
Thompson,
if
I'm
people
gonna give this to
shoplifted,
you,
then of course they could
And you
stop.
can point out,
And of course, I didn't catch
Are you-
every single
are you
one.
comfortable
There was people
pointing on this
shoplifting while I was busy
you
catching a
want me to
shoplifter.
use your All right, show us about where you would park.
I parked right there, stopped right there.
Stopped in that area?
Yes.
And what you're telling us is that's where you saw the defendant, Rick Chow, and someone else chasing Cyrus across the parking lot.
Yes.
All right, you can have a seat, please. Thank you.
But he wasn't running. He was walking out of the store. I don't see where he was running so fast that he came out of his shoes. When did he come out of his shoes?
I'd like to show you what's been marked as states.
And they acted like that the dad
States
was like in the office on the
524
computer,
from states number 4, exhibit number 4.
and he just casually came out of the office to see what was going on and came up on the scene kind of halfway through. See, now she sees them running. Okay.
Tell me what you see in that video.
My vehicle and Mr. Chow and the other gentleman running.
And is that what you experienced on May 28th, 2023?
Yes,
And that caught your attention?
yes.
What did you see next?
I saw Cyrus run across the street. I saw a female, I guess, I don't know if this is safe or not. I saw her pick up his shoe.
And did you continue to watch this whole incident unfold?
I did.
And you watched from your vantage point right there at the corner that you just pointed out to the jury?
Yes.
Tell us what you saw from that vantage point.
At that point, I saw Cyrus run across the street, them chasing him. I saw Cyrus trip, and he got up, and I was excited because I wanted him to continue running, but he didn't get up straight up. I thought he tripped again, and he went down.
Did you at any point in time see anything in Cyrus's hands?
I did not.
Would you be at a point where you could see things that were in his hands?
Yes.
What happened next? And you can take your time.
I turned my vehicle around and went down to where they were located at. I stopped.
Oh, TMZ.
I'm gonna ask, is everything okay?
Fake news, fake
He
news.
said,
I don't
"No,
trust
call
them.
911.
I don't even know if the
Stop
story's
there
real.
now. Before you drove down to see what was going on, could you see, you said Cyrus fell a second time?
He fell, he tripped over the curb, and then as he was getting up, he fell down again, so he didn't get upright. He didn't get upright to where he was.
What were the two men who were chasing him doing?
I saw the son. I saw both of them chase him, and then when I drove down there, I can't at this point because I had to turn my vehicle around. So I had to look left to make sure no car cut me. So then I drove down there, and when I stopped and asked if they needed help, was everything okay? The son, they was distance apart from Cyrus. Cyrus was in the middle of them, and Mr. Chow was in front of Cyrus. Cyrus was already laying on the ground, and the father was near the position where his head was at.
So let me ask this, just to make sure I'm getting this chronologically correct. Before you drove down there, you saw them run in front of your car.
Yes.
All right, and you saw him fall a couple times.
Yes.
All right, and then as he fell, you saw him, when he fell the final time, can you tell us where they were positioned?
I cannot tell you.
Can you tell us what, if anything, you saw Mr. Chow, the defendant in this case, doing, or his son doing when he fell the final time?
The final time when I saw, he was already moving towards the front of Cyrus.
Okay.
And the son was behind Cyrus, but a little ways off from where Cyrus was at. It's like the son ran up near the curb and stopped. It's like he didn't move no further.
And you saw Cyrus fall the final time?
I did.
Was he ever pointing towards them or doing anything towards them that you could see?
No, that I could see, no.
And did you ever see anything in his hand?
I did not.
So when you actually went down to the scene, you said you drove down there. Did you at some point engage or have a conversation? Well, let me change this around a little bit. What is it that you saw when you finally got down to the scene? You said that you saw Cyrus on the ground. Tell me what was going on.
When I got down there, Mr. Chow was down on his knees. Cyrus was on his back. And Mr. Chow has his hand out. And I asked, where'd the blood come from? Are you bleeding? Are you hurt? I said, who's hurt? And he said, him. So I looked at Cyrus and I said, where? Where? Because I didn't see no blood in it. And so by then there was another female and Mr. Chow, they rolled him over and they raised his shirt up. And I saw the hole in the back. And they rolled him back over and I cleared. By then he had leaves in his mouth, and I cleared the way because he had started making gurgling. So I thought he was trying to breathe. So I was trying to clear him so he can breathe. And I told them to the female and because I didn't know how to do CPR. So I told them to do CPR because he's trying to breathe. And I told him to do CPR. So the young lady started doing chest compression. And Mr. Chow was giving CPR mouth to mouth to him. And I just told him to keep on.
And you tried to do what you could to help with the situation after Cyrus had been shot.
Yes.
Do you know who shot Cyrus?
I don't know who shot, but I know when I went down there, when I turned my car around, went down there and stopped, Mr. Chow was in a shooting stance where he's standing upright with his legs and he had his arms.
See, I told you.
Like, can you stand and demonstrate to the jury what you mean by shooting stance? And hold on for a minute, let me move this. May she come down again, Your Honor?
Yes, sir.
When I drove down there and stopped, the scene was over here. And I rolled down my window and he was in a stance like this.
And what did you do when you saw Mr. Chow in a stance like that, the defendant, Mr. Chow, in a stance like that?
I asked him, was everything okay? And he said, no, call 911.
And is that what you did?
Yes, I had my family in the car, so I needed to get them out of danger and drove them up to the next apartment lot. And then I ran back down. And as I was going up though, I was calling 911, but I was so nervous because I needed to get back down there and help them. And I just gave the phone to my daughter because I couldn't get the information out.
Oh, he shot that boy in the back.
Court's indulgence, Your Honor.
Yes, sir.
So I'm going to show you what's been marked slide 20 of State's Exhibit No. 4. You should take a look at that, please. 21. I'm sorry, slide 21 of State's Exhibit No. 4. So we loop back a little bit just to go back to the beginning of this. What is it that you saw? Did you talk about shoot?
Shoot came on.
Okay, and that's what you saw?
I saw him run, on the red, bright red
Could you see?
sweatshirt, so I was able to see him. But I saw a shoe that's white and it just flew off as he was running.
Could you see his face?
Oh. I saw his face.
Tell me what you saw.
He just looked frightened, scared. He looked like he needed help.
And how
But clearly he was no angel, right? He had a gun on him. He was not making the best life choices, but
Like a kind of child, just in trouble, just
he didn't run out of the store. He walked out of the store. They ran after him, which
That would compel you to do a little
made
bit
him
more?
run
Yes.
Why is that?
to get away from them.
It's like one of my grandkids, one of my kids, you know, just looked scared, and I just had to help. I could not do nothing. I could not do nothing. My daughter wanted me to. I could not. The best thing I could do was just get my family out the way. And I didn't mind if I got hurt, but I needed my family out the way, and
I'm thinking,
And that's what you did?
and that's what I did.
And later you had an opportunity to speak to law enforcement about what you did?
Yes.
You did that. And let's just be clear.
this is looking like,
You're not any relation to anybody in this case, correct?
No.
You were with your family.
Yes.
And you watched all of these things unfold.
Yes.
Mr. Chow.
With motives.
I mean, that's what it looks like to me. It looks like this kid walked out of the store, and it looks like the Chows
As you, your daughter, and
faced him.
grandkids were in that parking lot, you watched Cyrus run by. What, if anything, was in his hands?
I saw the backpack on his back, but I didn't see anything in his hand.
And as he ran down Spring Street, what was in his hands?
I didn't see anything in his hand.
And as he fell multiple times, what was in his hands?
I didn't see anything in his hand.
And from your vantage point, you feel certain you would have seen if something was in his hands?
Yes.
Thank you, Your Honor. That's all I have.
Cross examination.
I'm going to say racism is a huge factor, to be honest with you. At South Carolina, Columbia, South Carolina, it is mostly black. And I'm just going to be real with you. Like, you have, let's just be real. These Asians, they own a store. They're probably getting shoplifted from a lot. They're probably getting, and it's mostly black. I mean, so they probably assumed this black kid is in their store stealing from them. I mean, that's probably exactly what they thought. And, you know, I mean, it's just, no. But it's nothing like the defense described. The defense made it sound like the son and his mom, they actually confronted the kid before he left the store and was like, hey, did you take something? He said no. He leaves the store. They made it sound like he ran out of the store, made himself look guilty or whatever. And then they made it sound like the dad was in his office and he goes running out after, you know, the chase had already ensued.
I need to ask you some questions.
Yes, sir.
None of that matches.
You testified that you were with your daughter, you went to this store to purchase something to drink.
Yeah. So again, like we always say, innocent until proven guilty. We have to see the evidence. And opening statements and closing arguments are not evidence.
You said turn off of the
Yeah.
park lane
Right.
to
Yeah.
Spring Tree, and then you say
But-
you needed to pull into the parking lot of the station.
Yes.
And maybe when we get this going.
Even if there was waters in his bag, even if he did steal the water, even so, you don't get in a shooting stance.
In a moment, when we get this figured out.
Yes, China.
Your
I'm.
SUV, you were riding with.
We're all in a consensus here.
Your daughter's name is Kennedy?
Kennedy.
We heard
Those
those opening statements did not match what we have seen so far.
She's not a baby.
She's a young lady, but she was seated in the passenger seat.
Yeah, this was
No, Kennedy was behind me. My
out
granddaughter
of
was
realm.
on the passenger side.
So which side of the automobile was she sitting?
You can have 100 lawyers, and this is not going to make
And are
sense.
the windows in your vehicle are tinted?
Yes.
That and again, y'all know I'm not one of those that's like all big on racial stuff, but this is
Let me ask you to step
I'm
down
gonna
again.
be honest. This has definitely got race is definitely in this.
And our solicitor has hidden the pointer. Oops, there it is. So, as you did before, would you reach up there and show the jury
But I know that being from the South,
where your vehicle
No.
was?
Yes, I pulled off Spring Tree.
Columbia, South Carolina is predominantly.
So up
I mean,
beyond that bush
there's
line?
probably you could probably throw a rock and not hit another Asian.
And so your view would have been down the road, and so as you testified, you watched through your window. Windows were rolled up in your vehicle, I think?
Yes, they're legally tinted though, they're not.
Okay. And the three people you saw run past you, would you kind of give the jury an indication with your pointer there where they ran by you?
And they're definitely trying to paint this 14-year-old as a thug, right? Because he had a gun.
Stepping off all the steps that he started running. So Cyrus were here and the other two gentlemen was.
But you live on the
just
streets
there
of
from
Columbia,
the
South
field.
Carolina.
The shoe flew off. The lady came and picked it up. I saw them go down because I had backed up.
Oh, Lord.
And let me ask you to stop you there. You saw the shoe come off somewhere around that red car? Or
Yeah, because that's when he had to start running.
do you recall?
Because he wasn't running.
I saw the lady come and pick it up.
But that was sometime later that she came and picked it up.
Until that point.
Yes, they was already off. Yeah.
All right. And did you see the gentleman you're calling Cyrus, did you see him throw 2 cell phones away?
No.
Didn't see that.
She said she didn't see anything in his
Anything
hand.
else away?
No, I did not. I didn't see anything in his hand.
Okay. Now, if you'll point up on that, you have to take a step up to get there. Point about where you believe that Mr. Belton, that's the person you're calling Cyrus,
Girl, you didn't. I ain't trying to say that. Did I say they was your cousins? You claiming them, not me. I'm just saying. You know how it is in Columbia. That place is crazy.
Ran across the street.
You got to do what you got to do to survive. Okay?
Somewhere in there.
Just say Columbia is crazy, man. It ain't the greatest place to be.
So your recollection is that it wasn't all the way there, much closer?
I cannot,
And I understand.
yeah, because he ran across the street.
All right.
Yeah,
you'll have a seat, man.
Yes, it was. It was like, girl, it was what the clip. It was the clip. The clip was loaded and around in the chamber.
Are you aware that the sheriff's department indicates that the distance from the store
And it had
to
a
where
sight. It had a laser sight on it
fell was
and a flashlight.
No, but when I was down there, when I looked back up at the store.
He was
I
ready to go.
myself saw like the tip of the
Locked and
store.
loaded,
I
baby.
couldn't see
Locked
the
and
whole
loaded.
Store itself. So the distance, I don't know, but I know when I looked up there at the store myself, I just saw like the tip of the store. So it was kind of, I couldn't see, you could see the lot in the store. You can like see.
But your view from through your rolled up window
Got that light.
is 130 yards.
I don't know the distance. I'm not.
But let's go back to when the 3 individuals ran past you. You didn't know who these people were.
No.
You did not know what was happening.
No.
You told the jury you didn't see anything in the first person's hands.
Girl, they got some cheap gas there though. Where's the cheap gas in South
No, I
Carolina?
didn't see
Rock
anything
Hill.
saying.
Rock Hill, South Carolina got the cheapest gas.
You just saw him step out and shoot.
I saw him running, and when his leg went back, his shoe flew off. So I didn't see him throw anything. I didn't see a cell phone.
And was he carrying the backpack, or did he have it looped in his arms in a backpack traditional position?
I don't think I can't recall if it was looped in his arm.
I can't live in South Carolina, man.
I thought it was on his back. And I was sure because
One of my best friends lives
You
there.
certainly
He
didn't
lives
know he
in
had a
Columbia.
9mm pistol
No, I
hidden
did
in
not.
his clothing
I did not.
in the front of his. Remember what he was wearing?
Yes, it was a bright red sweatshirt. He had on some darker jeans and some white tennis shoes was white, and sweatshirt was red.
Do you remember that it had a big pocket on the front?
I can't recall seeing a pocket. If
Now,
it did, I
the
wanna know.
second and the third people who were pursuing him or following him. The first, let's not confuse you or the jury. The first person you were calling Cyrus.
Yes.
The second person, do you now understand what his name was? Andy?
The son?
Yes.
Okay.
That second person you saw?
I saw, I guess, Andy and Mr. Chow.
All right. Well, you saw Andy running after Cyrus.
Both
Yes.
of them. Yeah.
And Andy had nothing in his hands,
I can't recall what they had in their hand.
so you didn't notice whether he had anything.
I didn't notice if he had anything in his hand.
And the third person was the father, Mr. Chow, the gentleman seated over here.
Yeah.
You recognize him today?
Yes.
All right.
From
And
the
he
store.
also didn't have anything in his hands, did he?
I didn't see anything in his hand.
And he was following his son. He was behind his son, wasn't he? As the videos have indicated.
Yes. It seemed like, well, in my view, it just seemed like they was running, so whether side by side or behind, but they
And
was
so
running after
you
him.
testified
Did you
that,
finish?
I'm sorry, I apologize for interrupting. Please finish. Do you remember what you were saying when I interrupted you?
Repeat the question and I can answer again.
Well, you saw, I think I asked, you saw nothing in Mr. Chow's hands. And
That's
he was,
correct. I didn't see anything in his hand.
and he was following his son. He was behind his son. As, and I said before you answered, as indicated on videos that have been seen.
Yes. What I saw, I just saw them running. I can't,
Yeah.
I don't know who was in front, behind. I don't know. They was together running. That's what I saw.
And so then you saw the three of them proceed down the street 130 yards, or whatever the distance was. And you
Yes.
say that then you saw the person you're calling Cyrus fall.
He tripped over the curb
All right,
and
and
went
you-
down and proceeded to get back up, and then he went down. He didn't get all the way up.
And you weren't able at that distance to see what he tripped on, were you?
He tripped over the curb. I saw that.
And when he began to get up, were you able at 130 yards to see that he had a gun in his hand?
No,
You couldn't see whether he had anything in his hand or not.
no.
The, you remember that, you remember seeing Andy Chow when this
Yes.
young man fell? Do you remember seeing him backing up into the middle of the street?
No. When I saw him, he was just standing still. I didn't see him back up.
In the middle of the street?
He was just standing still near the curb.
And you had no idea at that point that Cyrus had a 9mm pistol in
No.
his hand? When you saw him fall, you saw everyone stop. All three of them stopped.
Saw him. I don't know what they was doing. I saw my eyes was focused on him because of the red sweatshirt. I can't recall if they were backing up, whatever, but I saw him trip over the curb, get back up, and then trip again, and he went down, and that's when I went down.
When he fell, neither of the Chows jumped on him, did they?
I didn't see it. I didn't see them jump on him, no.
Okay. They didn't touch him. They didn't jump on him. They
I don't
didn't
know.
attack him. In other words.
There was a time period where I had turned my vehicle around and I had to look left to make sure no car was coming. So whatever happened in that short period of time for me to look left and turn it back and go, I don't know what happened.
Well, that's not the time period I'm asking. I'm asking you about what you've testified about. That when you saw him fall, neither of the Chows jumped on that young man when he fell.
No, I didn't see them jumping on him, no.
And the second time you say he tripped or fell, you don't know whether maybe that's when he was shot. You don't know.
I don't know.
In fact, you never heard a gunshot, did you?
I did not.
And when he fell the second time, or went down the second time, you did not see either Chow advance on him, attack him, did you?
I did not.
Now, the solicitor asked you about speaking to the sheriff's department. You went to the Richland County Sheriff's Department at their request.
Yes.
And gave an interview.
Yes.
In that interview, you mentioned, and it is correct, that you and your daughter participated in the 911 call.
Yes.
The 911 call was made after the second time Cyrus fell down.
Yes.
And in that Sheriff's Department interview, you indicated, as you said today, you were right there. Let's see. You were right there in that spot, though you, in the 911 call, you were not able to exactly explain where you were. You knew you were at the intersection of the corner of this gas station.
I could not, because I was just so frantic at that moment, I could not recall the street I was on, and I was nervous, and I handed the phone to my daughter to finish the conversation.
And so you never saw a gun in anybody's hands.
No.
And when you mentioned you turned your car around, you drove down, and you drove past where, well, you stopped where this, where the young man was, and Mr. Chow and his son.
Yes.
And you rolled the window down, I think you said.
Yes.
And Mr. Chow, this gentleman, the first thing he said to you was, call 911.
After I asked him, was everything okay? He said, no, call 911.
And again, you didn't know there was a gunshot.
No.
You and your daughter went up to what, one of the parking lots,
Yes.
turned in and pulled over and parked,
Yes.
and you walked back down.
I ran down.
Ran down. And your daughter's what?
My daughter after me. Yes.
Okay. And when you got down there, you saw Mr. Chow, this gentleman, Mr. Chow, you saw him giving this young man, you saw him down on his knees, giving this young man mouth to mouth.
No, sir.
What, don't you recall telling the sheriff's deputy when you were interviewed on, let's see, July 25th, roughly a month after this, that you watched Rick doing mouth to mouth and saw the brown stuff came out. And then you watched him try to do mouth to mouth again.
No, sir. When I went down there, he was on his knee.
Mr. Chow.
Mr. Chow was on his knee. By then, another young lady came down, and she was on my left-hand side. She went down on her knee. I asked him about the blood on his hand, because someone was injured. I need to know who was injured. I asked him, was he okay? Are you hurt? Who's hurt? And he said, him. I looked over at Cyrus, down at Cyrus. I didn't see no blood nowhere. So I'm trying to figure out where this blood come from, who's hurt. And that's when they both rolled him over. I saw the hole in his back and just a little blood around it. They rolled him back over. I got the leaves out of his mouth and I told him they need to do because I cannot do CPR. I asked them to do it. The young lady started doing the chest compression. He started doing mouth to mouth.
Okay, so he Mr. Chow did indeed give attempted life-saving measures, including mouth-to-mouth resuscitation, right there on his knees in front of you, trying to save this young boy's life. Even to the extent.
Yes.
Even to the extent that that young man aspirating or vomiting, Mr. Chow cleared his mouth and then proceeded to go back to a
No
mouth.
testimony about him aspirating and vomiting.
Sorry?
Your Honor, I believe that the testimony is in the record. The commentary.
I'll allow a question.
It was not pretty. And you yourself did not, do you know how to give mouth-to-mouth?
I do not know. That bothers me today, that I could not help him. And the only thing I could do was just clear his mouth with the leaves. And I couldn't do anything else but to stay there with him because he didn't have nobody there with him.
But Mr. Chow did apparently give mouth-to-mouth resuscitative efforts to save his life, right there in front.
Ooh, she is so upset.
That's all we have, Your Honor. Thank you.
Anything on the record?
Poor lady.
I'm fine.
I'm sorry, we gotta rehash this without. So, Mr. McCullough just mentioned that this, the defendant, Mr. Chow, was giving life. He was trying to save this young man's life, is what he said, right? And that's after he shot him in the back, right?
Well, Your Honor, I object to that because this is direct, redirect. She's already said she didn't see a gun, didn't see a shot fired.
Go ahead and ask the question and see where.
Okay. So, Mr. McCullough asked, or he said you went through this long litany about what happened right there, and said the defendant, Mr. Chow, Rick Chow, was giving him mouth to mouth, trying to save this child's life, and that was that.
Yes, I'm sorry.
And that was after Rick Chow had shot him in the back.
Yes.
And who did you see standing in a shooting position out of anybody of the three people who ran in front of your car?
I saw Mr. Chow.
The defendant, Rick Chow?
Yes, sir.
The man sitting right there?
Yes, sir.
All right. So you said that you clearly saw Cyrus didn't have anything in his hand, right?
I did not see anything in his hand.
You never saw him point and turning towards them.
I did not.
He was running the entire time.
Yes, sir.
And when he ran by you, he looked scared.
He did.
And who was running behind him?
Mr. Chow and his son, I believe.
And did you ever see Cyrus turn around and confront them?
No.
Kept running away from them.
Yes.
And they continued pursuing him the entire time. Now, also in questioning, Mr. McCullough said you didn't see a gun because he had it hidden in the front pocket.
I didn't see no gun.
Okay. Was that because it was hidden in the front pocket?
I didn't see no gun.
And have you seen somebody shot, killed, or dying in front of you like that before?
No.
And you were a little bit frantic, is the word you used?
Yes,
A little bit upset.
yes.
Did you do the best that you could to tell the police what you saw?
I did.
And at the end of the day, you didn't see a gun in Cyrus's hands. That'd be a yes or no?
I didn't see a gun.
Okay, did not see a gun.
I did not see a gun.
Okay, that's all I'm saying.
Good gravy. How many times you got to say it?
Thank you. Thank you, Ms. Carson.
Thank you, Ms. Carter.
All right. So I got.
I do your Mel Roach.
Yeah, y'all.
Girl, you late to the party. You need to move it. Shake your tail feather. We're not supposed to be able to hear you.
All right, ladies and gentlemen, we're gonna take a short break.
A break?
I know y'all had a break when we were discussing the matter. Well, none of us have had one yet. So we're gonna take our afternoon break for, let's just say 10 minutes. We'll be back out. Yeah, about around between 4:20 and 4:25 will be here. Again, don't stay okay. Next step, so make sure it's on.
Well, this is not looking good.
Any other questions?
And I don't know if you saw the video, but he was not running out the store. Alex, like another people just walked in. Are getting loud?
And again, we want to thank you all so much for joining us right here for this special coverage right here on WLTX Plus. Right now,
Okay, well, we can't watch that. Yeah, so I don't think he was running. Yeah, so he didn't run out of the, so the defense, when they got up into their opening statement, they made it sound like the young man ran out of the store. He ran out of the store so fast that he ran out of his shoes, and that the owner's son ran after him, and that the owner was sitting in his office and he had to get up from his computer and kind of, halfway through the situation came out and went to see what was going on. And he was kind of midway into the situation. And when he ran out to see what was happening with his son, that's when he found out his son was like, no, he has a gun. And that's when he pulled out his gun and shot the kid to protect his son. That was how the defense made it sound. When in actuality, this kid walked out of the store, and he didn't start running until the son and the father, they actually ran out of the store and started chasing the kid. Then the kid started running in the parking lot. And had to run so fast that he came out of his shoes. And then the kid started, when he started running, the two were chasing him so fast that that's why I think that from where they found the shell casing and where they found the kid, his body, it seemed kind of strange on the body cam, because I was like, that's not adding up. Where the shell casing was found and where the kid was found, I was like, that seems kind of far. It seems almost like Mr. Chow had to have been kind of in a stance position. It doesn't seem like he was in a position where it just seemed kind of far. So that's why I needed to see that. I need to see an expert get up there and say he actually was standing afar in a stance. And then when she got up there and said she saw him standing in a stance position, that makes me wonder, yeah, I don't think that so it's not how the defense made it sound. The defense made it sound like the dad came running out, like, what's going on? What's happening? And the son was all like, he has a gun. And the dad just like willy-nilly, oh my gosh, I have to, they made it sound, and then they made it sound like the kid was pointing the gun at the son, but I'm not seeing all that now. So, and that, and he didn't run out of the store. He walked out casually. So none of the stuff that the defense said, that's why his opening statement was so long-winded, because he had to fluff it up to make it seem like there was more to the story that was not there. So that's why we should have known when his opening statement was so long. I mentioned that too when he was doing his opening statement. I was like, dang, this is a really long opening statement for the defense. So I guess I should have caught that when his opening went so long, because that was an extremely long opening. Because the prosecution's opening wasn't that long. Because they know they have a case. And their witnesses will speak for themselves if they could ever get through the witnesses. So this will be. But as soon as she said he was in a stance, I knew it, because when the first responder got on the scene and he saw the shell casing at one location and where they found that kid laying, that did not make sense to me. That didn't add up. I knew that didn't match. So I just think that's terrible. Yeah, the prosecuting opening statement was really fast. I didn't even get to see the whole opening statement because I was fiddle farting around with my setup, because I just got this all hooked up this morning. So, and then I didn't know I was going to do a live today because I didn't know there was trials today. And I woke up this morning and was like, oh, I guess I should try to live stream, because I was going to wait till tomorrow. But I was like, no, if I wait till tomorrow, it'll be the second day of a trial that I know nothing about, and we'll all be playing catch up. So I thought I may as well start it today. So I was trying to get everything hooked up this morning. First thing. So here we are, trying to play catch up on this trial that I've never heard of. And then I saw Carly Gregg's appeal, and I wanted to make sure we didn't miss that. I think Carly Gregg might do the appeal just based off watching the prosecution and all the questions they were asking the prosecution. It could be possible. The judges they didn't go easy on the prosecutors. So it could go either way. I mean, the defense was shaky. They didn't help themselves, but I feel like she could, the prosecutors might set precedent and let this go back to the lower court, just because I don't think they were sitting too well with the whole no parole understanding, that they didn't like the idea. I just got a feeling that they didn't like the idea that there was no possibility of parole at all. Like none. That life meant life, which is weird because life should mean life. I mean, I would think that in other states, Mississippi, that's so strange that no other state, when you say you get life, that other states, it doesn't mean life. It means, oh, so in about 10 years, you're going to be up for parole. But in Mississippi, it does not mean that. It means actual life, but only for certain crimes. So for her crime, it means life. Yes. Life means life. But in other states, though, not for capital murder, it does not mean that. In most states, it does not mean life. It means so in Mississippi, if you say life for capital murder, it means forever and ever, amen, you're going to prison. But you don't have to say it without the possibility of parole in Mississippi. In other states, you have to add that caveat, without the possibility of parole. But in Mississippi, you don't have to say that. So I think that's what they're trying to get changed. Well, you heard it here first, ma'am. Yes, she did have the plea offer. That's right. She sure did. She had the plea offer of 40 years. And that's right. I know. Man, she would have been out in her, like, my age. Ow. Yeah, that girl, I mean, just the video of her doing what she did. I mean, it's just shocking. And you can hear her mom, screaming. It's just so messed up on so many levels. And then she calls her friend over to check it out. It's just wild. Kids, I just don't understand, like, what has happened to the minds of Well, she lured him, like, it was like she was trying to lure him home early. Like, when are you coming home, honey? You know, like she was just like lying in wait. So weird. Oh, we're back.
So you grew up on the north side, northeast side?
Yes, sir.
Are you slightly familiar with the northeast side of Columbia?
Very familiar.
Just making sure we're all clear in this new.
Are you any relation to anybody in this case?
Thank you.
No.
And in fact, you're under subpoena to be here today.
Yes.
Were you a witness? to
Oh, yeah,
something that
Elmo
took
slippers.
place Back in May of 2023?
Yes.
All right, in May of 2023, were you working?
Yes.
What were you doing at that point?
May of 2023, I was working for TD Bank still on lockbox services.
Okay. And your experiences at TD Bank,
Hey, bird.
just talk about some of the roles you've had there before.
I've been a teller, customer service representative, IT specialist. Now I'm a lockbox processor.
So you've been there for quite some time.
Yes.
And you dealt with the public, you dealt with multiple roles at TD Bank.
Yes.
All right. Now, back in 2023, May of 2023, where were you living?
Greenbrier Apartments.
All right. And is that in Columbia area, Richland County?
Yes, it is.
Can you give us a little bit better vantage point of where that is in Columbia?
Off of Springtree Road, Park Lane, Springtree, I believe.
Okay. I'm going to show you what's already been marked, page 15. Okay.
Was she there? I don't remember her.
Take a look at that if you would for a moment. See if you can familiarize yourself with that photograph. Are you familiar with that?
Yes.
Tell me what that looks to be.
This looks like Springtree Road, and the beginning of the photo is Park Lane.
And is that the vicinity that you lived?
Yes.
All right. Can we publish that on the big screen, please? There we go. All right, so you said, and if I could have the witness step down briefly, you know?
Yes.
Okay. Careful, what you step coming down, please. So come on down here if you would. And if you look up top, you can give me this pointer. Tell us about what we're talking about. If you can walk me through as I ask you a couple of these questions.
Okay.
All right, so you said, show us Springtree Road if you can from here. That's Springtree? And the one that runs perpendicular directly in front of that is what?
Who keeps clicking their pen?
And you were living about where back in 2023? So at the top of the screen is the Greenbrier apartment complex?
Yes.
And that's where you were living back in 2023? Yes. All right, you could have a seat, please. Thank you, ma'am. So if we concentrate specifically on May 20th, 2023, can you give the jury an idea of what you were doing that day?
We had just came back from seeing The Little Mermaid.
So tell me who we is.
My mother, my daughter, and my niece.
Okay. So you're going to see
Oh,
Little
she's the
Mermaid?
daughter.
And tell us what was happening with that.
As far as when we were coming back home,
Yes, when you were coming, what were your plans for the evening after seeing Little Mermaid?
okay, my mom was dropping me off, but I didn't have anything to drink at the house, so I was gonna stop by the corner store right there, that Shell station, to
Corner
grab
store?
something to drink.
Okay. Now you said the corner store, excuse me, the Shell station. Again, I'm showing council states 28, and I'm sorry, states 18 and 16, which are already in evidence. So you talked about a corner store. Let me show you states 16 and 18 and tell me if you're familiar with those.
Yes.
All right. And tell me what you're seeing in those photos. And you can actually look it up. The screen, I believe, it may be up in a moment. I'll publish it.
This is the Shell gas station.
Okay. And so that first, man, so that first video that we showed was an aerial view, meaning a kind of a bird's eye view of it. This is closer in. This is the Shell station that you were going to that particular day that states 16?
Yes.
All right. And did you go to that Shell station often?
Yes.
All right. Now, about how many times, if you could just kind of count in your head roughly how many times you've been inside that Shell station?
I can't count on my hands. It's been too many. I've lived in that area for over 3 years. So that was the gas station I frequent.
Okay.
So.
And so having been in there before, you'd kind of had a chance to walk and look around the store. Is that fair?
Yes.
All right. And was there anything about the decorations in that store or the pictures in that store that would bring your attention to things?
What's alarming is when you walk in the store, you see all the photos on the wall.
Okay, so let me show you what's been marked.
It's the who's who about town.
Take a look at this. Tell me if you recognize if you're familiar with that view.
Yes.
Tell me what you're seeing generally.
Stop clicking the pin.
The clerk stand and the photos.
Okay, and you see several photos, correct?
Yes.
All right, may I have that back? And it's stage 52
Stop
that is up
stealing
on that
it.
board, the photos that you're talking about above the clerk's head. Is that a fair and accurate representation of what you would see on a daily basis or however often you shopped in that convenience store?
Yes.
Right. Did you have a chance to have conversations with the clerks and people who were in that store?
Yes.
Do you see any of them sitting in the courtroom today?
Yes.
Who do you see sitting in the courtroom if you know a name?
Mr. Chow.
And where is he seated?
He's seated over there.
And again, the record reflect that the defense, the witness is what about Mr. Chow? Yes. Okay, the defendant in this case. All right, so if we focus on the 28th, you were heading home that evening, is what you said. What kind of vehicle were you guys riding in?
BMW X5.
Okay, BMW X5?
Yes.
And that was your mom's car?
Yes, it was.
And you said your daughter was in the car, you were in the car?
Yes.
Where was everybody positioned inside of that car?
My mother was driving. My niece was in the passenger seat up front. Me and my daughter were in the back seat.
Okay. And you were, and so again, you said you're in the back seat. I'd like to, and what, if anything, occurred as you were coming home and turning on the Spring Street to go to that store?
We pulled into the gas station. As we were pulling in, Cyrus was running out, and behind Cyrus was his son and Mr. Chow.
Okay. So I'd like to show slide number 20 of states exhibit number 4.
Look, that's an Asian thing, man. They'll put you on blast. That wall of shame.
So tell us if you recognize a vehicle that you would have been traveling
See,
in
look,
on
he's
May
just
20th,
casually walking out. Look, I didn't take anything.
Just passing.
I'm walking.
there.
I'm walking. Look,
And when you say right
they
there,
running. Look,
do you need to step down or can I, is that the one that's, there's a,
I can describe it. There's a red sign in front of the car, and then we are right behind that red sign there.
okay. And so as you pulled into that gas, did you take a ride into the gas station?
Yes.
All right, and what did you observe when you took a ride into the gas station?
Cyrus was running out. His shoe had fell off, and he was holding his pants up with one hand and pumping his arms with the other.
All right. And when you said he was running out, you said there were people behind him. Do you recognize in this courtroom anybody who was behind him?
Yes.
Tell us who you recognized.
Mr. Chow.
The defendant, Mr. Chow? Rick Chow?
Yes.
All right. Now, I'd like to show, and tell us what was Cyrus, what was his demeanor as he was running away?
His eyes were big. He was running pretty fast.
Okay. Was it a casual stroll like you walking through the park?
No.
Describe or show the jury, if you could, with your hands, what you were observing as Miss Cyrus came out of that store.
Cyrus was holding his pants up like this, pumping his arms like this.
You said you saw a shoe.
Yes.
Tell me about that. Explain that a little bit more.
Before he hit Springtree Road, his shoe had fell off.
I'd like to show slide 21 of State's Exhibit number 4.
See, he didn't start running until he realized they were running after him. He was walking.
So based on slide 21 of State's Exhibit number 4, did you see a shoe?
Yes.
Okay. And is that a fair and accurate representation of what you viewed as you and your family were in that car pulling into the gas station?
Yes.
Can you describe about, although it doesn't seem to be in the video, where you all would have been positioned, where your car would have been, so you could see those things?
Goodness. This car is kind of in the way, but we were at the corner at the end of this parking lot area. Makes sense.
And what was Rick Chow doing at that point, the defendant Rick Chow?
He was running behind his son.
And the son meaning Andy Chow?
Yes.
We show State's slide 27, I apologize, from State's Exhibit number 4. Can you describe, well, first of all, does that vehicle look familiar to you?
Yes.
Whose vehicle is that?
That's my mother's.
All right. And you were inside of that vehicle?
Yes, I am.
Tell us what you saw.
So Cyrus was running out, his shoe came off. He was pumping his arms and holding his pants with the other arm. He crossed the street and he tripped over the curb.
What happens when you go to sleep?
At that time, he got back up. I see Mr. Chow step out. He had his arms up. And then we see Cyrus fall again to the ground. He kind of like crawled basically to the place where he passed.
And I'm going to go back through that with you slowly. I want to show you something real quick before we go to this next portion. I'm going to show you State's Exhibits and 3 markings, 32. Not never shit, y'all. Take a look at that, if you would, please. Does that look familiar to you?
Yes.
Tell me what it looks to be a still shot of.
It looks to see, there's a still shot of Andy in front of his father and me and my family in the car. And Andy and his father are running.
Is it fair to say it's a still shot of the video we just watched?
Yes.
All right. I'd like to enter State 72 in the evidence.
Objection? No objection. All right, it'll be State 72 without objection.
May we publish that, please?
Yes, sir.
So as Andy and Rick are running after
Well, dang,
Cyrus,
you can see
you
his
said
his
you
gun.
saw the shoe come off.
Yes,
You said that you saw a little bit farther down the road, Cyrus trip or fall multiple times.
yes.
Okay, now let's talk a little bit more. You said that you saw him standing. Go back through that. I do not want to put words in your mouth.
I'm sure. So we pull in. We stop right where you see us. They run across. Cyrus trips over the curb. He gets back up. We see Mr. Chow go and step out, put his arms up, and Cyrus trips again and kind of gets back up, but he's like a crawl to where he passed away.
What, if anything, did you see in Cyrus Carmack-Belton's hands when he ran past you?
Nothing. So when he was in the parking lot, well, running out the parking lot, he had his like book bag right here. When he tripped the first time, he didn't have his book bag anymore. When he was in the parking lot running, he was pumping his arms. It was visible that he was running.
And from your vantage point, could you see if there was anything in his hands?
There wasn't anything in his hands.
I'm going to show you what's been marked in State's Exhibit 20. Can I hand that to you?
Yes, sir.
Does that vantage point look familiar to you?
Yes.
Is that where you observed all of the goings on Spring Tree Road?
Yes.
On May 28, 2023?
Yes.
Is that where you just testified you saw Rick Chow, the defendant in this case, and his son Andy chasing after Cyrus?
Yes.
Is that where you saw that shoe fly off?
Yes.
Is that where you saw Cyrus fall and the backpack fell?
Yes.
Is that where you saw after he tripped, he meaning Cyrus tripped over that curb, Rick do some kind of motion with his hands?
Yes.
No, I'm going to object to the lead. Come on. Thank you.
What did you see him do with his hands at that point in time? Him meaning the defendant, Rick Chow.
Okay. So after Cyrus tripped, he had his hands like this. You know, if I can.
You move this down. Can the witness step down here? Come on down, please. I'm gonna step in front of you. Thank you. All right, please continue.
Okay. If the jury is my vantage point this way.
And excuse me. So defendant child is right here. So where was Cyrus positioned?
Cyrus was in front of him.
Okay.
With it turned, we all facing the same
Could
way.
you turn me in the direction of where Cyrus would have been facing?
Yeah. Maybe a little lower because he had tripped and he was coming back up. Yeah.
More like that?
Yes, sir.
Or
Well, Your Honor, you can lead with words and you can lead with actions, and I object to either way.
Your Honor, she said lower, and I got lower.
Overruled.
So if I'm getting lower, more like this or more like this?
More like that.
All right. And so and is that when you tell us what you saw when you saw him lower in the position that I was just in?
So he tripped and was coming back up.
All right, so I'm positioning myself again. Somewhere in here.
Yes. He was on his way back up. Mr. Chow was already like this.
Did you see Cyrus Carmack-Belton turn around at any point?
No.
Did you see him point anything at Rick Chow or Andy Chow at any point?
No.
Did you hear anything?
There was a lot going on. My mom was in the car and my mom was in the car and a little hysterical. She said, "Is that a gunshot?" And I didn't really want to be involved with this. And I was like, "No, that wasn't a shot. That wasn't a shot." We had the windows rolled up, and so it was muffled. Yeah.
But even with the windows being rolled up and it being muffled, did that interrupt what you saw with your eyes?
No,
From the vantage point that you saw it?
no.
Now, your mother eventually, excuse me, drove down to the incident location?
Yes.
All right, and came back. Was there a conversation of some sort that took place between she and anybody?
Yes.
While you guys were still in the car?
Yes.
Okay, who did she speak with?
Mr. Chow.
All right, and did she come back to the scene for a brief moment?
Yeah, she circled around. So after the incident took place, she drove down some and she asked Mr. Chow, did anybody need help? Is anybody hurt?
So don't tell me what he said, but after that conversation, the driving took place?
Yeah, so she turned back around. We turned around and parked.
May I show slide number 30 of defense exhibit number 4?
Oh, the mom's like, she's done. Okay, who's watching the store?
What do you see there?
That's my mom whipping the car around.
Who do you see walking past that car?
I guess that's Miss Chow. I'm not too familiar with her.
If they're so worried about people stealing.
And is that the point you went back down to the scene?
Yes.
All right. And what happened when you went back down to the scene? I think you said, I don't know if the words come out, did you say you parked?
Yes, we parked.
Okay, all right. And after you parked, what happened? Let's start generally about what happened now. Be careful, don't tell me what other people said, but just tell me what you did.
We parked. My mom hopped out. I hopped out the car, and we went down to the scene.
Okay. What did you observe with your eyes?
I know. They're so
Mr.
worried
Chow was
about
sitting
thieves.
over.
Left the store unattended.
Cyrus. Yeah, he wasn't doing anything. He was just sitting there.
And did you interact with, what was the scene like for people? What was the scene like when you were out there?
My mom made it down there before me, and when I was walking down, there was another young lady. We kind of just walked down at the same time.
What was Cyrus doing?
Cyrus was laying there.
What was defendant Rick Chow doing?
He was just sitting there, just looking at him.
What, if anything, was the son doing, Andy Chow?
He was standing off. He didn't move after the incident happened. He was still.
Did you observe anything around the scene?
There was a gun by a tree over there. Cyrus didn't have his book bag. And it was Mr. Chow and Cyrus over there. Yeah.
And do you know who that gun belonged to?
No.
Did you see a gun in Cyrus's hand at any point in time?
No.
Court's indulgence.
Yes, sir.
Now, a couple more questions. Could you tell any type of just the sizes of the people who were involved in this entire incident that we're talking about?
Sure.
Okay, tell us what you could observe.
Andy is much taller than his father. Cyrus is much shorter than Andy. Yeah.
Now, you've, and I don't want to make this personal, so I'll try to ask this as gingerly as I can.
One is Asian.
I thought Cyrus was like 16. Yep. I thought he was 16.
You look like a grown man?
No, he looked like a child.
So all questions after this time,
Motion made. Thank you. We have slide 27. One you have on the screen. It's a, I think it's still still, but it's the child's going across the parking lot.
And he goes rabbit hunting. His feet are caked in dirt. I just realized I had to go and get his feet wipes. I just went through like nearly a whole pack of feet wipes. He needs a bath. He's a stinky boy. Don't look at me like that. You're a dirty bird. Oh my gosh. And we don't have a washer and dryer in this house. We have to go buy a washer and dryer. Look at them in a full-on sprint. Look at it. For some water. For what you thought was some water.
So that's your the automobile that you were in?
Yes,
Where were you in that automobile?
I'm in the back seat. It would be on the passenger side.
Passenger side.
Yes,
So that would be to the left side.
well, the right side is the passenger side.
So, all right. So are you on the left side?
I'm
or
on
right
the,
side?
I'm in the back seat on the right side.
And this photograph
Who's on first?
states Exhibit 72. Is that pretty much the way the thing looked that evening?
Yes,
And it was that dark? It was 8 o'clock at night,
it was bright outside.
bright outside. Okay. And you know the distance, well, your automobile stopped in the parking lot, yes?
Yes, well, right, turning into the entrance.
Okay, there was a bush there on the side, and you pulled up to that bush,
Yes,
and you saw these three people run past.
yes,
And nobody had a gun,
no,
you heard no yelling, no cursing,
no,
you just saw three people run past.
yes,
Now, you said that you saw the first person who you described as called Cyrus. You described that he appeared to be pulling up his pants.
holding his pants.
Could he have been holding a pistol in his waistband?
No.
How do you know?
You seen the pants in his hand.
Well, didn't he have a long hoodie on, red hoodie?
He had a hoodie on. You're still holding your pants. You can still see him holding his pants.
Did you know he had a pistol?
No,
You didn't know anybody else had a pistol?
no.
And the windows in your vehicle were rolled up.
I'm sorry?
The windows in the vehicle that you were in were rolled up.
Yes, they were.
And you saw you saw Cyrus's shoe come off.
Yes,
Did you see him throw things left and right as
No.
he ran across the parking lot?
no,
Didn't see him throw cell phones.
no.
Did you see him throw the backpack down the road?
He didn't throw the backpack. He tripped and fell. When he got back up, the backpack wasn't on him anymore.
Had it been on his shoulders?
It was on the shoulder.
And now, the distance from where your vehicle was, and your vehicle stayed in the same stationary position, same spot, until after he fell down. Is that correct?
Yes,
And fell down and didn't get up.
correct.
And would it surprise you to know that that's 130 yards?
Okay.
Well, I mean, you wouldn't quarrel with that number, would you?
I wouldn't know the distance. And I seen it.
So it's longer than a football field. So if you're standing at one end of a football field, it's even further than that.
I can see down a football field.
But as you described and exhibited here, these people that were 130 yards away, Mr. Chow had his back to you, as did, you couldn't see Mr. Belton, you couldn't see what he had in his hands, could you?
I seen what Cyrus had in his hands when he ran across
Right,
our
he didn't have
car.
anything in his hands, that's not my question.
When he got back up from tripping, his hands were, he was like crawling when he crawled. So his hands were on the ground.
All right, but when he started to get up,
Neil got mud everywhere, dirt.
you said, I think
Mud.
in your, you and your mother made a 911 call, didn't you?
Yes,
You remember telling the dispatcher he might have got shot, I'm not sure.
yeah, it was a lot going on. I was processing my emotions.
You remember telling the dispatcher that you believed he might have stolen something.
That's what was being said.
You told the dispatcher, I don't know who shot him.
I did say I don't know who shot him.
You, so you also testified a few moments ago that, let's see, that you saw him trip multiple times
Correct. He tripped twice.
and crawl to where he passed.
Correct.
You did not include that detail in your 911 call.
I didn't.
Do you remember talking to officers, Officer Carter, I believe? Or Deputy, I believe it's English or Carter. Do you remember speaking to officers at the scene?
Yes.
You didn't include that detail. You never told either one of them that you saw this gun, that you saw him shot and crawled to where he died. You didn't include that in your explanation to them of what you just seen. And this was something that was moments before.
Yes, I did.
Well, you think you did?
I know I did.
Well, I'll be happy for you to find it in this transcript, but if you think you did, you think you did.
I think
And when you went to the sheriff's department on July the 25th, 2023, did you tell that detail to that investigator as well?
I was asked far as vantage point. I wasn't asked what happened.
In fact, nobody asked you any questions about what happened.
No, they wanted to know vantage point of where I was.
They wanted you to draw a diagram, didn't they?
Yes.
Go ahead.
Yeah.
So, you better finish. They asked you to draw a diagram?
Yes.
Did they question you about anything about what you saw?
No.
Did they question you about how far away you were?
They asked where I was and to draw the vantage point of what I seen.
And you didn't
Ew.
volunteer anything like you testified.
Girl, if I see a snake, I'm gonna freak out. I'm already freaking out with the wasp and the bees. I just found a boatload of dirt on this sofa back here. I didn't realize he had all this dirt caked up on his feet. I just went in my bedroom and there's dirt all in my bed. I don't know what we don't have a washer and dryer. This is freaking me out. And I can't just like throw him in the shower.
Yeah, let me get one
Our bathrooms are
clarification here.
are so weird in this house.
When you
I'm telling you, do
saw
not
these three people
make
run
rash life
past your
decisions
vehicle,
while going through a nervous
did you
breakdown.
know
It is not the
that
best idea.
third person in line, the person following the tall, younger man, was Mr. Chow?
Yes.
You knew him to be the store owner.
Yes.
But in the 911 call, you recall saying, I don't know who shot him.
Yes, I said that. I was processing. I didn't want to be involved. When my mom stopped the vehicle, I told her to keep going because I did not want to be involved. My mom called 911 and she handed me the phone.
Okay.
And my mom has been hysterical in the back. And I have to be calm and process what I see. I did not want to be involved. Thus the reason why I said, I don't know. Because I didn't want to be involved.
But in the 911 call, and on the scene, you didn't tell the police that you saw Mr. Chow shoot anybody.
I didn't want to be involved. I was made to be involved.
It doesn't matter. We know he shot him.
Yes, sir. Now, there's a set of questions about the statement that you gave. Isn't it true that you gave a statement to the police, a written statement on the 28th
Yes.
of May 2023?
Yes, they called me back. I went home and they called me back to make the statement.
She does not want to be there. What's the king roller? I do need to get a clothesline.
That's fine.
I'd like to have this marked for ID purposes only.
Ask the question, dude. Oh, a lint roller. I still need a clothesline. The king roller. I was like, what's the king roller? Yeah, I do. I got a lint roller. I need to get whatever he carried in. Like his feet were caked in dirt. I was pulling off clumps of dirt. But it rained last night. So he got some mud. Dude, what are you asking her? And he is so stinky. I don't know what he's getting into.
Now, you asked a series of questions. I'm going to show you State's Exhibit 82 for ID purposes only. Take a look at that and tell us if you recognize that document. You recognize the document?
Yes.
Whose handwriting is that?
This handwriting, I believe it was the officer that I was speaking with, but that's my signature at the bottom.
That's your signature at the bottom? So this is what you told the officer, what the officer wrote down in your signature.
Yes.
And in this statement, it says, you're making this statement free, I can't read today. I make this statement of my own free will in the court without reward or intimidation. All of the above is the truth, the whole truth and nothing but the truth. Do you see that written on that document?
Yes.
Okay. So at 21:23, military time, so I'll do my math. I can't do math. 9:23?
Yes.
On 5/28/23, you gave a statement to them?
Yes.
All right, and the question, did you see a kid with a gun? Answered no. When he was running, he was holding his pants up. Is that what that says? Is that what that says?
Yes.
Okay. Did you see any weapons on the ground? The answer is yes, a gun by the tree. Did you see how the gun got there? Answer is no. You remember saying those things?
Yes.
Did you hear the owner say anything about the kid? Answer, you say no. Did you hear anyone say anything about being shot? Answer is no. Do you remember saying those things?
Yes.
And you remember in this, you're saying that you heard a pop?
Yes.
You saw the kid fall down?
Yes.
You called 911?
Yes.
You parked the car and you walked and the owner was shaking him, trying to wake him up?
Yes.
You remember saying that?
Yes.
You said that you saw people run out of the store?
Yes.
The kid, the store owner?
Yes.
The owner and his wife?
His wife came after Mr. Chow.
That you followed on Spring Tree? And the son in the corner, and the son and the owner had the kid boxed in?
Yes.
The kid fell down and they were on arm's reach of him, and that's
Yes.
when I heard the pop. You said that?
Yes, I did.
And you said that on May 28th, 2023, correct?
Yes.
At 9:23 in the evening, correct?
Yes.
And that was about an hour and some change after this incident took place, right?
Yes.
All right. I'd like to show slide 21, please.
We used to have one of those portable like RV style
While we're doing
washers
that,
and
there's
dryers.
this question about
The washer.
130 yards.
Yeah. Anyway,
Did you measure?
I finally sold it
Do you know if the 130 yards is from the front door of the store or from
last
the tip of
year.
the property when it goes off of their property onto the public road?
That thing was a champ.
I
It
don't
was
know
awesome.
where they were.
But did you have a clear vantage point?
I seen it all.
All right, so will you play that, please?
Because we never thought we needed it. I hung on to that thing for years. But every place we ever lived comes with washer and dryer. I'm telling you, that kid,
Wear glasses, hard to see. Is it light or dark outside?
It's light.
And that's a fair and accurate representation of what the weather conditions were like at 8:02 or so on May 28th, 2023?
Yes.
Was not dark.
It was not dark. It was dark at 9:22.
Now, you said in your direct, you saw Chow pointing at Cyrus.
Yes.
Cyrus was on his knees, getting up on the ground.
Yes.
And not too long after that, you realized that he'd been shot.
Yes.
And he passed away out there.
Yes, he did.
Do you know who shot?
Mr. Chow shot him.
That's all my questions.
Thank you, Your Honor. So I noticed in this statement that you gave, you say, I pulled into the store with my mom and I saw 4 people run out of the store. 4
Yes.
people. The kid, the son of the store owner, the owner, and his wife.
Yes. She picks the shoe up.
But you say here that you saw 4 people run out of the store.
Yeah, so Cyrus, then his son, and Mr. Chow. And a few seconds after that was his wife.
You didn't say that. You didn't know that these videos existed when you gave this statement.
Yes, I did. There's cameras all around that store.
I'm sorry?
There's cameras all around that store.
Oh, so you knew that there was going to be a video that would accurately reflect what really happened, not what you might
I didn't
say.
know this was going to take place at all.
And then you say in the statement, the kid fell down and they were all in arm's reach of him. And that's when I heard a pop. Right?
Yes.
You didn't say that you saw the pop.
Can you see a pop?
Well, you didn't say you saw a gun. You said the boy got up and tried to run and he fell back down. You never said you saw Mr. Chow shoot this young man. You never said you could see the young boy's hands and that he didn't have a gun because you couldn't see him.
That wasn't asked at that time. You see the question on that document. It wasn't asked.
Well, but you
No,
wanted to make sure.
she
that you told
was in the
story.
parking lot.
I was answering the questions I was asked.
I see. Well, nobody was in a hurry to finish, were they?
There was a lot going on. I was in a hurry to leave because I didn't want to be involved. My daughter was there. My niece was there. My mom was hysterical. There was a lot going on.
And there's nothing in here about this young man crawling to die.
I stated that he got back up when he passed away. After the second time he fell, that's when he crawled over to his passing point.
Well, ma'am, what you said is, if you need the statement, I can provide it to you. Here. You want to read along with me?
I don't.
You don't?
I don't.
Well, I want to make sure that this is a fair opportunity to give midway on that first page under A, colon, the sentence that begins with owner. You say in the next sentence, the kid fell down and they were all in arm's reach of him, and that's when I heard the pop. The boy got back up and tried to run, and he fell back down.
Yes.
No crawling.
He
No,
tried to run.
No, Mr. Chow
And he
shot
fell
him.
back down. I wasn't asked that. They asked me what I seen.
And on the second page, you were asked, you say you saw a gun by the tree.
Yes.
And the tree you're referring to would have been within a couple of feet or a foot of where this young man died?
It wasn't a foot. It was closer to the road, but that's where the gun was found.
And you were asked, did you see how the gun got there? And your answer was?
No.
No. Thank you.
All right, all done? Yes, sir. That's all I got.
Oh, my.
Ms. Carter, you can step down. Thanks for being here. Our son,
Well, I thought he had more questions for. I was like, good Lord. This poor woman.
All right, ladies and gentlemen, we're gonna recess for the day. We get started again tomorrow, hopefully, at 9:30. Again, don't discuss cases with anyone, don't do any research on your own or anything of that nature, and we'll see you back here tomorrow morning, ready to go. Have a good evening.
Oh, my goodness. All right. Well, that is day one. Well, what do we think about this one? So it started out, right? We thought we were in another pickle of a trial where we were like, oh, this sounds crazy. This sounds like another one of those weird situations where we're going to be in a crap storm of a falsely accused kind of situation. The defense opening was was good. It was convincing, right? But we always have to go into these trials where obviously it's our justice system, right? It's innocent until proven guilty. We have to listen to the evidence. But I will say, just based on the camera footage, right? It's complete opposite of what the opening statements were. The kid did not go running out of the store. Of course, that he was making questionable life choices. Okay. I think the defense is hard focused on the fact that this kid was carrying a gun. Why was he carrying a gun? That is some questions that, we would have and would be able to ask him if he were alive. Unfortunately, we can't ask him that. But I just think that this is, I wonder if Mr. Chow was offered a plea deal for lesser charges. I really do want to see if this team of lawyers, what they're going to come up with, because this is really looking, pretty bad for Mr. Chow. I'm thinking that they need to come up with something a bit more, a bit stronger, because this is looking pretty bad. So let's see how this goes tomorrow, and let's hope to God that this gets a little bit more, the pace. Let's hope that the pace gets a little better. So, but thanks for joining today. I really appreciate it, and welcome to my new home. Hopefully it will feel homier. So yeah, as of right now, I'm leaning towards guilt, but we're only in day 1. So let's see what happens. But that's, based on the video that I'm seeing, it's not matching. It's not matching what the defense opening statement was, but we shall see. I wonder if the son is going to get on the stand and testify to what he saw in the store. I mean, he is a pretty integral part of this puzzle, since he is the one who started, he saw the young man in the store, and he did question him, and he did chase him. So I kind of do wonder what he's got to say about this whole shenanigans. So yeah. So we'll see you tomorrow morning, bright and early, 8:30. And there are some trials happening June 1st. I'm going to look up and see which ones they are, but I know there's some good ones. I want to say, I might be wrong. It could be Lindsay Shriver. It might even be the Auburn beauty queen trial. I can't remember. If you find out, let me know, but I will let you know. We'll see. Now I have to go clean off my bed that my dog destroyed with muddy feet, because I'm die.